in this great country. And we ask, Lord Father, a special blessing upon our military and those that have died for the opportunity for us to be able to come before you. And we ask all this in your name. Amen. Go ahead and bring the meeting to order. Ms. Mayhaw, if you don't mind calling roll.
Yes, sir. Mike Mendez.
Present.
Tom Butler is absent today. Luann Morgan.
Here.
Fred Moses is absent today. Catherine Rodewald.
Here.
Robbie Shaw.
I'm here.
Deborah Yurko.
Here.
We do have a quorum present. At this point in time, I'll accept a motion to excuse the absences of Commissioner Butler and Commissioner Moses.
So moved. Second.
A motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. I know that we have executive session, but I'm going to jump down to item G for our internal auditors. So at this point in time, I think Commissioner Yurko, is there anything that you would like to tell us about the audit? I think you're the head of the audit, finance audit.
Thank you, Chairman. Do you want to give a brief synopsis?
Sure. Thank you, Mr. Chair, Madam Chair of the Audit Committee. We did have a chat. I'm Kim Lopez Gonzalez with Garza Gonzalez and Associates, the internal auditors for TDLR. And we did have a quick audit committee meeting this morning to review the results of the risk assessment for fiscal year 2016. And the, is it not on? Is it, can you hear me now?
Yeah.
Okay. So what you have before you is the audit plan for fiscal year 2016. Within that audit plan, we are recommending 2 audits, the IT area and also the tow trucks and the related functions of that program. Based on the discussions that were held as part of the audit committee, the audit committee members felt that which area was that? The water well drillers, I believe?
And
would-
combative sports.
And?
No.
Well, there was discussion on both, right?
Yeah, right. Just
Water
water well
well
for this
and
year, for
combative
2016.
sports. They felt that those 2 areas should be considered also as part of the audit plan. And based on further discussion, it was discussed that the combative sports area is undergoing some major changes. So perhaps that would be an area for fiscal year 2017. So what was decided in the audit committee was that we would go forward with what was included in the audit plan, but also adding the water well drillers to that. Water well drillers and pump installers to the audit plan. What management indicated is that they will go back and look at the budget, our budget, to see if if any changes had to be made to ensure that we had sufficient allotted time, so that we can spend sufficient time to perform the audits in that. So I believe what we're going to go forward with is the 2 areas, adding the water well drillers, and then also included in the audit plan is that we would perform the follow-up, as we always do, on any comments and comments that were included in last year's audit that have not been fully implemented. So we'll also perform an audit follow-up, and we'll also prepare the internal audit report, the annual internal audit report for fiscal year 2016. So that will be the final audit plan that will be modified to include that.
Any questions? Yes, Commissioner Shaw.
I have a couple of questions on your risk assessment when you went through the different programs. Was there any particular reason why the 2 stood out, just briefly, the water well and the combative sports? I think all of them are important. I think all of them have a high risk, but explain to me why those 2 stand out.
I believe that the 2, they were actually brought forward from the audit committee members, and because they have not been audited ever. Those were the 2 that, there's also more that have not been audited ever since 2006, that we have a history here. But I believe maybe they have some concerns with that just because of the what's been occurring in those 2 areas. So they felt, maybe based on the information that you have as board members, that you know that those are 2 areas perhaps that have been, I don't know, Commissioner Yurko, do you have some concerns maybe in those areas?
Well, I believe, and my understanding is that the commission wasn't actually consulted, but our executive director and possibly some
All the
other
staff, the directors.
other staff had the discussion with you all and brought those 2 to the forefront.
Yes.
And then in addition, we thought, as we were looking over it in general, based on the ones that haven't been addressed since 2006, that maybe they should be definitely targeted and moved up the list.
That makes a lot of sense. So my second question, and maybe to the staff, based on the history that we've had with the internal auditor since 2006, there's got to be some sort of systematic approach or methodology that's been applied to doing the assessments. Whatever is garnered, the information that's been garnered with the 2006, from 2006 till today, would we be applying that sort of same thought process or the ideas that have been taken from those audits to the new programs that we're bringing on board?
Yes, we will. The same risk assessment to evaluate the materiality, the last time it's been audited, the results of a previous audit, the financial exposure, those same elements would apply to the new programs. We'd probably give them a little bit of time to be with the agency, so we can have them for about a year and a half to see how they're working out, and then say, let's look back and see how things are working out.
You see where I'm going with this, that those new programs don't have to wait for 9 years for them to be audited. We can
Correct.
fast forward with all the stuff that we've learned since 2006, and maybe apply some of the
Yes.
items that the auditors have brought up to our attention.
Just to further clarify our audit approach, as Brian has indicated, we do go through the 8 risk assessment factors that we apply to each of the audit topics, and we do solicit feedback from management and any other responsible parties for those programs. We take that information and we apply it to to our risk assessment, and that's how we come up with this. Also, to answer your question about the additional programs, this year there is that additional program of the driver education and safety that was added to TDLR from TEA. You inherited that program from TEA this year. But that did fall into the moderate, and as you indicated, we don't have to wait. You're right, we don't have to wait. We don't always have to do high-risk areas. You know, just because they come up as high risk doesn't necessarily mean that we have to audit them. We could also always go to a low-risk area or a moderate risk, and we can get that feedback from management or from the board members, commission members, because there may be some you may just want those programs audited because they've never been audited, but maybe due to the size of them, they don't fall into the high-risk area because of the materiality. That plays a major factor in it. They've never been audited, so perhaps they don't have any outstanding comments and recommendations, which is also another factor that we take into consideration. So just because they fall into the low risk doesn't necessarily mean that we have to put them aside for another year. So if there's ever any concern from any commissioners, you know, we can always look at those programs.
Thank you, ma'am.
Right, Commissioner Shaw, also, one of the things we discussed in the committee meeting was that the increase in the number of programs that we are continuing to receive really dictates that we reevaluate the budget for the internal audit, and we'll be looking at that to increase that budget so that we'll be able to take in more of these audits as we go forward. The budget's based on the dollar amount that we set under the contract and what we budgeted, and then it's limited by the scope and the billing hours for the internal auditor, so that they will get as much accomplished as they can within that dollar amount. So we really do need to expand that dollar amount.
Very good.
Well, I'm
And,
glad you mentioned that, because that's exactly what I was going to ask, because we have these new programs coming on, and
Yep.
as we're adding new programs, it's going to, if we didn't expand that budget, it was going to minimize the time
Correct.
on each particular program that we could do, because, I mean, we're doing 3.
We're doing
No,
3.
we're only doing 2, that was another issue.
Okay.
Because we've gone from 4 originally to 3. And I understand that the first year, you didn't realize the scope of what it was gonna require. And then with the follow-up, to make sure we're actually doing what the audit revealed, it does take up more time, so it's gone down to where we only have 2.
Okay, so we're going to do IT and tow trucks.
And that's it, unfortunately.
Oh, I thought we were-
still
I
think
thought-
we need to
don't we do
consider
water well
adding-
drillers?
That's
we
what it
would like
started
to.
with. She was giving you the progression that it was going to be 2, and now it's going to be 3.
We're hoping it'll be 3. We
Okay.
encouraged Bill and Brian to search the budget to find the dollars to do this in 2016. 'cause I
Yeah.
think it
Well-
needs to
And
be
Mr.
done.
Chairman, the number of audits is not the determining factor in what can be accomplished. It's the scope of each of those audits. So if you've got a major program that's got a lot of different elements, it's going to take more audit hours than, for instance, one of the small programs that is I guess, a low-maintenance program, I call it, so that it doesn't come up to those levels of risk that you need to do that extensive a look at.
What might be beneficial, and I did appreciate you mentioning bringing the commission in, or at least my chair, into the discussion over which way we should go on the auditing, but it might help for you or Brian or someone in the director's office to break down what is considered a more farther-reaching program than like what you were just describing, one that might be smaller, which is a different question to ask than high-risk, medium, and low, which is what you did, which I think is necessary too. But it might be beneficial when trying to figure out what else we can add in, if we can see how they would work time-wise.
Mr. Shaw?
So here's where I was going with this, and I think maybe this may be a solution. One, I would like to see that there is some sort of a scheduled audit for each of these programs that we've taken on, whether it's a 4-year cycle or an 8-year cycle, or within 8 years, it has to be audited. So I think part of our next business plan, maybe we add that in there so that we can then accomplish the budgetary requirements as well. Put maybe a performance requirement that high-risk programs should be audited in X number of years. Moderate risk programs should be, audited in so many years, and vice versa with the low-risk ones.
And if you have that in place, we can consider that as time since last audit, because then we can know that it's not, so that it would raise it to a higher level, even if it's a small,
Correct.
small
Yeah.
So I
area.
think that would help then us, it basically it's like a barometer. It'll help us gauge where we're at year after year when we're assessing the audit. So the committee will then decide, which items are moved forward, which items are not moved forward. But you have a high risk turnaround time, you have a moderate risk turnaround time, and a low risk turnaround time.
Commissioner Saul, Brian Francis, maybe just to add on to that, maybe the approach could be something where we have a mix. And so in any audit cycle, you're doing 3 high risk, 1 moderate, 1 low, and that way, the low ones always come in. So
I
you've
agree.
got a combination where you address that. The other thing to address Commissioner Yurko's concern or thought was maybe in the risk assessment, I'm talking to our auditors now, but maybe in that risk assessment, we can add a piece that speaks to the scope or complexity. Materiality kind of brings that in, but having another variable that speaks to the depth and the complexity of it. So it's just another tick mark, and then it still allows it to be quantifiable.
Well,
as we're going
I
through the
agree, but I
assessment.
still think it needs to be separate from theirs, because I think that addresses a different issue, that addresses a time budgeting issue for us. Whereas they're giving us what I think is their legitimate concerns based on their feedback from you and the
Based on
different
the risk
parameters.
inherent in it.
Right,
Okay.
is a separate issue. I think that's great, but I think you all need to do that, rather than incorporating it into whether they feel like it's where it should fit in their
Okay.
scope, is my thought.
I see it. It makes sense. We do a risk assessment, and then there's a scope assessment. And then that can give us the mix for what's high, what's low, what's moderate,
Right.
and then the complexity of it. Okay?
But I do agree with Commissioner Shaw that we do need to have an overall plan, because when we did get this, I guess this is my first, what would this be called? Internal audit overall, whether our plan is for next year, to find out that we really don't have a plan for addressing several of them. Like, I think we came up with 8 have never been audited, 13 haven't been audited in 5 years. So we do need to have an overall game plan of how we're going to approach forward on that.
Right, especially because you're getting more programs, inheriting more programs.
Correct.
And right now you have 34. That's a lot to cover.
Yeah.
I mean, it takes, that's why you don't see them audited like in 5 years or 6 years, 8 years, because there's so many programs, auditable areas, potential audit areas that we can audit. And if you're getting more programs, of course, you're going to have more of a gap. If we don't cycle it the way that Commissioner Shaw has indicated, maybe we do a high, a medium, and a high, a moderate, and a low, to cover things like that.
And it's not that I think, we're going to find a gotcha moment in the audit. It actually reveals a lot of successes in the organization of how we're covering things. So I just think it's a positive, a win-win on both sides.
Madam Chair, one more thing to consider is that when we have these audible functions down there, you have programs and then you have functions. So the budget function, the cash receipt function, when those broader function categories are being audited, we are picking up the financial aspect of the VPP and the property tax professionals. So it's not that a program never gets audited, but when we look at a function, we're picking in most of the programs, and then when we're focusing on a program, we're narrowly looking at just the activities for that. So we are picking up some of the lesser programs or smaller programs. Excuse me, if I say the program now, I'm in trouble. So there are other programs that don't have as much volume to them that
Just
are
as
Low
important.
maintenance program.
Brian, just stop. I feel like I'm at home. I just got in trouble again. Leave it at that.
Any other questions?
So I would move to adopt the audit plan for fiscal year 2016 as presented.
I'll second that.
Motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Thank you very much.
Travels back to San Antonio before the rain hits. Worse.
We're going to go back to item D, executive session. Commissioners will now enter executive session in consultation with staff attorney pursuant to section 5510711. We'll receive a briefing from general counsel concerning pending and contemplated litigation, settlement offers, advice from general counsel on legal matters authorized by 5510712, and 5510774, discussion of personnel matters. request for a continuance.
Mr. Chairman, Mr. Brian Francis.
Yes.
Could we get you a little bit closer to that microphone, sir, please?
How's that?
That's perfect. Thank you so much.
Still very white going on there. We have a request for a continuance on this. Do you
We
know?
don't oppose it.
Okay. So, Commissioners, if you're okay, we can go ahead and continue this to the next meeting.
So moved.
Second.
We have a motion second to continue. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir. Let's go on to item number 2, which is Mike's Handyman Services. Go ahead, John.
Good morning, Commissioners. My name is John Medlock, and I am a prosecutor for the Enforcement Division. On February 21st of 2013, Robert Hallbaker offered to perform electrical work by submitting a proposal to the department's undercover investigators during a sting operation. The respondent, who admitted at the hearing to not having a license, submitted a proposal which included installing multiple ceiling fans and electrical outlets for $7,600. The department charged the respondent with a violation for offering to perform electrical work without having a license. The ALJ concluded the evidence presented established that the respondent did offer to perform electrical work without having a license in violation of statute. The ALJ recommended a penalty of $2,000 for this violation. I would recommend that you adopt the PFD as written. I'm available to answer any questions.
Any questions for John, Mr. Medlock? Is anyone here representing Mike's Handyman Services? Commissioners, discussion or a motion to be in order?
Motion to adopt the PFD?
Second.
Motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir. Item number 3, Scott Denny. You have a few cases, Mr. Sharp.
Sir?
Do you have a few cases there?
Intermediate this time, only 3, so.
Go right ahead.
And I take that's a hint for me to be brief. So I'm-
Yeah, I think so. Somebody speaking.
Mr. Chairman, Commissioners, my name is Ken Sharp. I am an enforcement prosecutor for the department. Scott H. Denny is the applicant in this case. On September 29 of 2014, Mr. Denny applied for an apprentice electrician license and an air conditioning and refrigeration technician license. The department proposes to deny those applications. Mr. Denny was previously licensed by the department as an air conditioning and refrigerator contractor and as a journeyman electrician. In 2010, while he was licensed, police in the city of Keller, Texas, learned that he was collecting child pornography. They went to his house with a search warrant and discovered that Mr. Denny had used the internet to obtain images and videos of adults engaged in a variety of sexually explicit acts with infants and minor children, including oral intercourse. At that time, Mr. Denny admitted to the officers that he knew what he was doing was wrong. Mr. Denny was 48 years old when the police raided his house and found the child pornography there. In January of 2011, he appeared in federal court and was convicted of possession of child pornography. The court sentenced him to 54 months in prison. Mr. Denny was released from prison on July 15th of 2014. He applied for the 2 licenses on September 29th of 2014, about 2.5 months after his release from prison. Because the commission included crimes involving prohibited sexual conduct and crimes involving children as victims in the criminal conviction guidelines for electricians and for air conditioning and refrigeration technicians, the department denied those applications. At his hearing before the administrative law judge, Mr. Denny testified and offered letters of recommendation, a letter that purported to be a psychological evaluation, and 2 letters he wrote himself. The letters from his wife, his family, and his friends are exactly what one would expect from close family members and friends. They largely spoke of his abilities and his desire to do the kind of work the licenses require. 4 of the letters were from friends who had written them in 2010, apparently for the federal court proceedings. Those letters shared one notably distinctive characteristic with the more recent letters. They all referred to him favorably as a good guy. However, at the same time the applicant projected that favorable image to his friends, those who wrote the letters back in 2010 and earlier, he was at that time acquiring and viewing the child pornography. Mr. Denny presented 2 letters from prison officials that proclaimed his integrity and his work ethic and abilities while in prison, where appropriate conduct is not only required but compelled. Now, the applicant also presented a letter from the clinical director of an organization called Psychotherapy Services and Yoke Fellows, or PSY. The ALJ erroneously admitted this letter into evidence over the department's objection. First, it refers to polygraph tests and results. And because polygraph tests and results are so unreliable, they are not admissible, and they have never been admissible in any judicial or administrative proceedings in Texas. Second, the letter gave the opinion of a person who purported to be an expert, but without any evidence or any showing that he was actually an expert. Third, the person referred to an evaluation tool without any proof that it was a valid or reliable test, or that he knew how to administer it or interpret the results. There was no evidence that the writer had accurate and complete information about Mr. Denny. Fourth, the letter writer offered an unfounded opinion about the evidence in the case and the applicant's likelihood of reoffending. However, the authorities who prepare the sex offender registry, the supervision authorities, prison officials, courts, law enforcement, they were not even able to assess his risk level, and they had all the facts, not just those that Mr. Denny chose to reveal in counseling sessions. Under Texas law, the letter from Dean Lauren of PSY was erroneously admitted and considered, and unfortunately the ALJ placed great emphasis on the contents of that letter. Finally, the applicant submitted 2 letters he wrote himself. The most telling information from the applicant appears in the letter he wrote specifically to the ALJ for the hearing. In that letter and in his testimony, he told the ALJ, and I'll quote, "I know what I did was wrong." And as I stated earlier, that's exactly what he told the police officers when they raided his house and found him in possession of the child pornography. At the hearing and in that letter, Mr. Denny described himself as a victim. He said he was sucked into viewing pornography, that it's very hard to get away from it, and that he's recovering from an addiction. In fact, at the hearing, all of the evidence Mr. Denny presented focused on what he wanted and what he felt and what had happened to him. He said, and I'll quote again, "I am truly sorry for the deep hurt that I have caused to my wife, family, and friends," end quote. Well, that's probably appropriate, but he lamented that the child pornography had taken him away from his work obligations and his family activities. But he said his life is better now. Not once in his oral or in his written testimony did he ever refer to the kids in those images and in those videos. Not once did he ever acknowledge or express regret that the demand for child pornography drives suppliers to produce it by forcing children to engage in acts of sexual abuse and assault to be filmed for the gratification of people like Mr. Denny. And not once did he acknowledge that making those children appear and sexually perform in those videos and in those photographs causes a deep and lasting pain for those kids, that it takes away important parts of their lives, parts that they're never going to get back. Instead, Mr. Denny seemed to downplay his crime by referring to the material simply as porn, and to illustrate in his letter to the ALJ, which was admitted as Applicant's Exhibit 1, only once out of the 18 references did he use the term child pornography. The other 17 references were simply to porn or pornography. Mr. Denny told the ALJ he was a recovering sex addict and he will never view pornography again. Well, only time will tell, and in Mr. Denny's case, simply not enough time has passed to allow a reasonably accurate assessment of whether he will be relapse and once again contribute to child sexual assault and abuse by acquiring and viewing child pornography. In spite of all this, the ALJ recommended the Commission grant the license applications. The ALJ found the applicant's work history prior to the conviction impressive, but failed to recognize that during his previous period of licensure and during his impressive work history, Mr. Denny accumulated the videos and photographs of children being sexually abused. The law requires Mr. Denny to demonstrate, not just claim, that he has the requisite trustworthiness and integrity to hold the license. The 2.5 months between his release from prison and the time he applied for these licenses, even the 10 months between his release from prison and the time of the hearing, is simply not enough time to allow him an opportunity to demonstrate that he now has the requisite honesty, integrity, and trustworthiness to hold a license. The department recommends that you reject the PFD, deny the applications at this time, and allow Mr. Denny the opportunity to actually demonstrate, as the law requires, that he is trustworthy and fit to hold a license. The department recommends that you deny the license applications. Thank you.
Any questions, Mr. Sharp?
I have one.
Yes.
How many videos and photos?
There were 5 in total.
Anything else? Any other questions for Mr. Sharp at this time? Mr. Scott Smith?
Yes.
Mr. Dean, I know you're also present with him.
Yes,
Do
sir.
you plan on speaking? If you do, I'm going to need one of these filled out on your behalf also, or if you're just going to allow Mr. Smith to speak for you. Okay. I'm sure you're probably aware, the only thing that we can accept is anything that was presented at the hearing with the ALJ. Anything outside of that, I'm sure Mr. Sharp will jump in, our general counsel will jump in and let us know if we start straying away. So make sure we just confine it, the comments to what was being presented at the hearing.
Understood.
Thank you, sir. If you don't mind, introduce yourself.
Thank
State your
you.
name for the record.
My name is Scott Smith. I'm an attorney here in Austin, Texas, and I've not had the pleasure of presenting before you folks before. So I will do my best to try to stay within your rules, and I am hoping to be able to provide you information that will assist you in the important decision you are to make. The
Excuse me, could you get a little closer to the microphone, please?
Sorry about that. Thank you. How is this?
Very good.
Great. Sometimes I may trail off, and if I do, I invite you folks to shepherd me back to the microphone. Okay. I want to provide a broader picture of Mr. Denny to help you with your decision. And the information that was presented shows Mr. Denny's married. He worked for American Airlines for 19 years until he was arrested. Started as general maintenance and worked himself up to becoming a crew chief in charge of all the air conditioning systems for American Airlines at Dallas-Fort Worth Airport. And in addition to that, the evidence showed that Mr. Denny also had his own business, ARMAC. So essentially, for 19 years, Mr. Denny worked 2 jobs. He has 3 children. They're grown children. And each of them wrote letters to support Mr. Denny. Each of these children are doing well today. One has a master's degree in architecture. Another one has her BS in chemistry. Is working for a hospital in surgery recovery with infants, and awaiting to start a program for a physician's assistant with the University of Texas. And the other one is finishing up his college degree now.
Mr. Chairman, these are things that are not in the record.
What is in the record is that each of these children support Mr. Denny. And in addition to that, what is also in the record, his wife supports Mr. Denny. She is here today. Her name is Kathleen. These are people who know Mr. Denny. These are people who have spent a lot of time with Mr. Denny. Kathleen has spent, since September 10th, 1988, when they were married, has spent every day with Mr. Denny. The children have spent their lives with Mr. Denny, and so I encourage you to look at their letters. You know, I'm trying to think about what is it like for you folks, making a decision like this and handling all the other matters you do, and I don't really know. The closest I come to understanding that is that my wife served, my former wife, served on the Austin Independent School District Board for 4 years, non-paid position, spent a lot of time, and had a hard time. It was a constant challenge to be able to get all the information. I would assume it is for you folks as well. You have a lot of matters to cover, I don't know if you've been able to read these letters. I doubt that you would have the time to read all the letters that were submitted on his behalf. I have them with me if there are questions. But these letters are telling. These letters say a lot about Mr. Denny as a human being. There are additional letters that were submitted. People who he's worked with, who speak incredibly highly of him. Letters by friends who have known him for a long time, 17 years, 18 years, 19 years, his whole life. That's Mr. Denny, the big picture. Now, Mr. Denny is here in front of you and all of these people, having to face the fact that he fell. He fell really far, and he fell really hard. Mr. Denny working 2 jobs to provide for his kids. At the age of 48, never with any other arrest history in his life, had his life changed that day. He was arrested and charged with possession of pornography. He had a lot of pornography. 5 of those images were of children. Now, I want to make some things clear with regard to Mr. Denny's fall. He did not have any contact with any children. That is unrebutted at all. I also want to make very clear something else. This in no way is any attempt by myself or Mr. Denny to minimize the impact of child pornography. I am not here to provide excuses for that. I'm not here to say anything other than that is wrong. And the children in those images are victims, period. There's no other way to put it. What I am here is to talk about also Mr. Denny's, not just his fall, but what he's done to get back up. You know, when life is going smoothly for us, it's really not that hard to be a good person. When your business is going well, when things are going well, it's not that hard. But the real test of a person, the real test of a human being, is what happens when they do fall. Then what? What do you do? And what Mr. Denny has done is what any of us, I think, would want to do, what all of us want somebody to do when we fall, or our brother, our sister, or anybody else falls. He did his best to get back up. He accepted responsibility first and foremost. The agents came to his house, he admitted immediately his wrong. He admitted it in court, and he has admitted it in counseling since then. The other thing he's done is taken steps forward. It's been 6 years, just a few days after, more than 6 years since he was arrested. His first step was admitting what he had done wrong to the agents. Another step was admitting in court what he did wrong, accepting his punishment. Mr. Denny, a person like many of us, had the very humbling experience of going to federal prison and spending many years there with other people who had fallen as well. In prison, he worked. He started off doing maintenance, and they quickly realized what skills he had, and the letters that were introduced from the prison officials attest to this. He was incredible in his skill. They don't just praise his skill, they also praise his work ethic and his integrity. He helped redo all of their AC systems in that penitentiary. He helped oversee all the maintenance. And before he left, he helped establish training programs so that they can continue to do things. Now, I understand that in prison there are a lot of rules and you don't have a lot of choices, but Mr. Denny went well beyond that. And that's part of the character that comes forward in the multiple letters that were presented at the hearing and which the judge read. I do take issue with my learned friend about the judge's decision. The judge's decision is not just based on what one therapist has to say about him. The judge's decision is based on all of these letters and all of this information. The judge's decision also considered the counseling he's received. He started at his release. At this point, he's been in the counseling for more than a year, about to finish the last part of his counseling and enter what's called the aftercare program.
So he is currently in counseling?
Yes. Yes, and that's actually required for all sex offenders. All sex offenders, whether they touch somebody or just possess pornography, and I don't use that word just in any way to, again, to minimize the impact of child pornography. But everybody must attend counseling, and it is arduous. You have to face who you are, where you've gone wrong. What I think is important in that kind of counseling, or any kind of addiction counseling where somebody gets hooked to something, and let's be frank about this. Some of us get addicted to alcohol. Some of us get addicted to drugs. Some of us get addicted to working too much. Some of us get addicted to pornography. You know, when you work too much and you don't take care of yourself, you become isolated from who you are and sometimes your friends and your family. And people lean on that. But what's important to realize is that this is one part of a person. And I dare say probably in some way, we all have parts that we are not proud of. We all have something that we'd rather not be up here talking about today. But Mr. Denny's is in the spotlight. Mr. Denny also revealed to his friends and his family what had happened. The people who wrote those letters know this and still write in support of him, and that attests to something greater than just his fall. It attests to Mr. Denny's character prior to the fall and after the fall. The letters are from, first of all, his counselor. Now, I disagree with my learned friend with regard to the counselor's credentials. This is not some flippant person with a couple years of college education saying, oh, I think he's a nice person. Warren Dean is the clinical director of the program that the federal government contracts with to provide treatment to sex offenders, to establish safety plans for sex offenders, to oversee what happens with them. She has a huge amount of experience and training.
Mr. Chairman, it's Brad Bowman, General Counsel. I'm sorry to jump in. I just want to make sure that this, the detail that we're getting into here is part of the record. And it may be, I just want to make sure that we're.
Is it a part of the record, Mr. Sharp?
Staying within those confines.
It is.
Just the letter is in the record. There's, Lauren Dean has some initials behind, I guess it's behind her name, but that's it. There's nothing else to show that she has any kind of the experience or training or contracts with the government and so forth.
Mr. Smith, you're basing that off the letter?
I am.
The initials?
I am, and the broader context of the letter that I have, and I would be pleased to provide a copy of it if you folks would like to see it. But what is telling is, number one, behind her initials are LPC for Licensed Professional Counselor and LSOT, Licensed Sex Offender Treatment Provider. And under that is Clinical Director, and off to the side are all the therapists who work under her. That letter concludes with this: Mr. Scott Denny has been accountable and has established good boundaries in the community. In addition, he has an extensive and invested support system and has indicated that he will not enter into private homes, but only do work in commercial environments. His access to children is removed, not only by safety plan, which she establishes, but also by his restrictions of supervision. This is a letter written by somebody who has known him for a shorter period of time, but known him on a very intense level. His probation officer wrote a letter on his behalf talking about his compliance with the conditions of his supervised release. His long-term friends he's known from church, many of which he's known more than 15 years, wrote letters in support of him. The common themes of these letters: honest, trustworthy, very hardworking, generous and helpful to other people. They talk about how he helps other people. They talk about him as he has letters from people interested in actually hiring him. People who have known him for a long time before his fall and after his fall 6 years ago. And they talk about him as a consummate professional who's highly skilled, trustworthy, and a high degree of integrity. In addition to the business side, the working side of Mr. Denny, the letters from his children are short, but really telling. Two of his children talk about, all of them support him. Two of them talk about they remember going on service calls with him as little kids. One of them talks about remembering that Mr. Denny went out to one home with, and I remember the term, repairing the air conditioning for a little old lady and not charging her for it. This is the, and when she talked with her father about why that was, he said, well, sometimes you can give a little and it can make a big difference. These are the lessons that he has provided on to his children who've gone on to do well. Now, the administrative law judge heard all of this information. That is her purpose. She has more time than you folks do. I'm trying to be respectful of your time, and I'm also trying to do a good and fair presentation of the facts of this case. But that administrative law judge heard all of this. And it was her opinion that he had carried his burden. She had a different opinion about the letter. She thought that this was correctly considered. She did not consider anything with regard to polygraph examinations. She based what she did consider as the other parts of the letter from the therapist. And she also considered all of the letters, 20 in total, that were supported on behalf of Mr. Denny by colleagues, friends, and family. She considered the words of people who have known Mr. Denny for close to 2 decades, who've known him, worked with him, gone to church with him, raised kids, shared family times with him. And she recommended that this application be granted. And she also recognized the restrictions that are already, and safety plans that are already in place, and it was her opinion that this application should be granted. Now, I understand each of you have your own roles, functions, jobs to do here. But I am asking you to look at all of that. We started this meeting today with a brief prayer, I notice. And I know that those people were saying prayers, maybe were coming at their prayers from different religions. You know, some people are following the words of Jesus. Some people are following the words of Moses, we Jews. Some people are following the words of Buddha. You know, it really, I don't think matters in some sense whose words you're following, because as far as I know, all of these religions and all of these thoughts recognize the fact that there are human beings are not single-sided characters. We're not all one thing or the other, and we are all capable of choosing our paths, making our mistakes, and also getting up after we fall down. My prayer is that we listen to that and we look at the entire picture, that you look at the entire picture, and I'm requesting the board consider these items and then follow the recommendation of the administrative law judge in this case. I know you have a lot of business to cover, so I don't want to eat up more of your time, except I do want to offer to answer any questions as well as I can, if any of you do, if you have them, that will enable you to do your job as well as you can.
Any questions for Mr. Smith?
Is Mr. Denny currently employed?
Yes, he is. What's your position? He's a lead maintenance mechanic for Smurfer Capital. Kappa Bates.
You stated that he's a recovering sex addict?
Yes, yes, and
Has
you
that
know.
been diagnosed or is that self-diagnosed?
No, that's diagnosed. And just to be clear, anybody who has ever been addicted to anything never gets better than being a recovering addict. It is something you go through for your entire life.
And you stated that he is currently in counseling?
Absolutely. And about to finish the main part and then graduate into the aftercare program where he continues then to help other people who have this problem in a supportive environment, much like AA meetings would be.
And he served 42 months in the federal prison?
Yes. Yes, he did.
Was released, is currently on probation?
It's called supervised release, actually. And it is, for all practical and intents purposes, like probation.
How long is that going to be?
Indefinite. And federal judges have the power to provide indefinite additional supervision, and they usually do, in my experience.
You stated that he is now going to be entering the last phase.
The aftercare
Right.
phase, that is correct, yes.
Is that for a certain period of time also?
That will probably be for several years.
Is there anything in place after that?
Yes. There are, in terms of there are safety plans while he's in the counseling that are very intense, very specific, and then monitored strictly. In addition to that, there are the rules of community supervision, which are also very strict.
Monitoring
And-
strictly by who?
By a number of people. We've got the counselor, who actually, in an interesting way, counselors typically are just sort of one-on-one the way we typically see them, but sex offender treatment providers are very different because they're responsible not just to the patient, they're also responsible to the courts. So they provide supervision and monitoring
And let me tell
in
you kinda what
addition
my
to the
concern
probation
is-
department.
Is that
Yes.
he is still going to be out doing work.
I'm not sure that I understand that question, or
Well, it's
or
not actually a
concern.
question, it's a statement.
Okay.
He's still going to be out doing work. And although you're stating that it's going to be in a commercial setting,
Mhm.
the license that's granted gives the opportunity to be able to go into residential. Now, I understand that you're saying that there's safety plans in place.
Yes.
But the way that we are set up currently is the opportunity to go into residential to do work is still there. The license granted allows that. And that's a concern of mine.
I understand it. I would like to address it if I have a chance.
Sure, go ahead.
Yes. I think it's a legitimate concern, and appropriate. But the system that is in place might be like our system of laws. The Constitution gives us, each state, the power to adopt a wide array of laws, but we decide within that which laws we adopt, which ones make sense, which ones are prudent, which ones we won't. Though the license may be broad in that sense, the actual restrictions in place will be substantial, and they are through the probation department. The United States Probation Department takes its job very seriously, and the supervision is extremely strict. So you have, I understand the concern, and I think the administrative law judge also asked the same question you're asking. What are the safety provisions in place? And recognized the safety provisions that are in place, the rules that are in place, the type of monitoring, not just that those rules are there, but how they actually get enforced. And they are a very, very high degree of monitoring and very strict.
Commissioner Yoka, you had a question?
What, okay, I keep hearing you say high and difficult. What are they?
Okay.
Does he have an ankle monitor on?
Here's what, yeah, I'll speak.
does?
No, I'm
Okay.
sorry.
Does he have someone that comes to visit him at his job site?
They have periodic visits.
And
They-
is periodic daily, weekly, monthly?
Actually,
yearly?
random,
Random.
randomly. And
So, and how long has he been out?
he was released in, what year?
That was January 2015.
In January 2015.
Okay, in the last year, how many times has someone randomly showed up at his job site?
Every month.
Every month. And one other.
He was released in July.
Yeah, but I was
July
released for the
15th
half.
of 2014 is what it said.
Mr.
Right,
Chairman,
right.
I'm sorry to interrupt, but the only evidence about his supervision was in that letter from Lauren Dean, and that part of that letter in particular is what the department objected to and filed exceptions to because it's in the inadmissible part of that letter. There's very little in that letter that's admissible.
Well, actually,
So that
Sorry.
wasn't into evidence, all the terms, just what Lauren Dean said she understood the restrictions would provide for. And even that was inadmissible, I would say.
Any further questions?
I would like to add one thing to this. The supervised release conditions, I believe, were introduced. And in addition to that, I am sure that the
Was it introduced in testimony or in the letter?
I believe that they were written.
So we've got a document on it? Because Mr. Sharp is saying that we do not.
And I could be wrong, but I'm going to look and see because
Well,
the only thing it
thank you
might
both
be.
looking.
In addition to that, the issue of polygraphs is a highly debated topic, and I want to make some distinctions here. The polygraphs are referenced in the letter by the counselor. Now, polygraphs are not admissible in criminal court proceedings. However, they are used extensively for enforcement. You asked about how do you watch what's going on, how do you monitor? There are frequent polygraph examinations by the sex offender treatment provider as to the compliance with the terms of the counseling, and those terms are rigorous, very, very rigorous. They address all parts of Mr. Denny's life. And so, and in counseling, he sees her every single week for multiple hours. And in aftercare will continue to do so. So this is not just to help Mr. Denny, which it is, but it's also a part of the safety plan.
Did you find it, Mr. Sharp?
We don't have that in there.
Mr. Chairman, this is Brad Bowman, General Counsel. We were just kind of checking as well. We think the terms were in the record, but not the testimony about how many times, that someone came to the job site or anything like that. I don't know that would
wasn't
be
in there?
in the
Okay.
record, but the basic terms of supervision, we believe were in the documents and evidence from
That
our
is
review of the
my
record.
belief as well.
How old was
Thank
Mr. Denny when this occurred?
He was 48 years old. He is now 54.
I can tell you that is also a concern of mine, is because of the fact that, I think as it's pointed out here, his crime was not of youthful indiscretion. 48 years old at the time. you know, some of the things that we take in consideration are the age of the individual at times, depending
Yes.
on the crimes, those type of things, which I think we've got a case later on that we'll be discussing. But at this point in time, when there's 48, that's a concern of mine. You mentioned that, I think you said there are some parts we are not proud of when we begin to start talking about our life.
Yes.
And how we fall.
Yes.
I think that anybody that has a beating heart has made errors along the way in their life. But at the same time, there are consequences to that. Some are rather short. Some may be prolonged and go on for a while. I can tell you that I think that in my opinion, I'll let you know, I don't believe there's enough time elapsed. I just don't see it. You know, it's really nothing that you can state. This is just my opinion.
Mhm.
So I think that there's some issues that I have. There's safety that I look at, and this is, again, I'm talking about myself. The commissioners all have their own opinion. I just find it very difficult at this point in time to deal with this.
You do mention something, though, that raises an interesting point, which is Mr. Denny's age at the time of the offense, 48 years old. So he went through 48 years of life without an offense and has had 6 years of life afterwards without an offense. Now, I might consider a context in which to view this. Somebody who has huge problems often manifests themselves immediately. Somebody who has a serious personality disorder will manifest it quickly. Somebody who has a terrible anger management problem, for example, may manifest it quickly. I think in the sense of an addiction, especially a subtle addiction, it's not actually, from my experience, extremely unusual for a certain person who's generally got a strong and good character, but has then developed a lifestyle that's overloaded with work, that goes off into that direction, for that smaller part of his personality to eventually grow to where it then becomes a problem and then gets noticed. Now, the good thing about that is that somebody who has a better background.
I don't want to cut off the legal, this is Brad Bowman, General Counsel. I don't want to cut off any legal argument, but I'm not sure this is really legal argument, and it may be veering off of the record.
Motion or question?
I was going to ask a question of Mr. Sharp, so.
Okay, is there anything else for Mr. Scott? Okay, Mr. Scott, go ahead.
Could you help me again with some of the timeline? When was the application made?
He made his applications for these two licenses after his prison release on September 29th of 2014.
2014, and his release was in?
That was July 15th of 2014. So just about 2.5 months apart.
Okay. I think, like the chair, I think there hasn't been enough time that has lapsed by, I think, to prove. I think with the licensures that we're talking about today here, TDLR doesn't have a specific licensure for just commercial, am I correct?
That's right.
I mean, this license can be used for both residential and commercial?
Yes, sir.
Thank you, sir.
Any further questions?
No,
For-
I don't have any questions. I have some comments too, though.
Oh, go ahead.
Because I think, when we consider issuing a license, some of the things that we do consider is what, the nature and extent of the crime and the amount of time elapsed. And historically, that's probably been one of the key factors in our decision is the amount of time elapsed to establish, if they're rehabilitated or not. And basically what you had was 2.5 months from the time of release, and been my concern mainly is the amount of time elapsed since release. And, you know, everything else, I feel like he complies. That's just been the, you know, the record of rehabilitation time. I do have a concern there.
May I make a motion?
Yeah, I was gonna say, if there's no further comments, I know that Commissioner Yurko does have a motion to make.
I believe that the ALJ has actually misapplied section 53.023, and I would like to make a motion to deny respondent both licenses. My basis for doing that is part of the discussions like Commissioner Morgan just stated and Chairman Arizmendi said about the nature of the crime involving child pornography, the release of a lifetime supervision, and we're only here at less than 2 years out. And I just feel that we need to make that motion.
So I think we probably have some conclusions of law.
Some
Oh, we
technical
do.
corrections, yeah.
Actually, there's a couple house cleaning matters, finding of fact 1, to change it from registered air conditioning and refrigeration technician rather than a certified license. Finding of fact 13, to keep the finding of fact, but to edit it to include has not demonstrated. And then conclusion of law 1, and conclusion of law 7, that it be denied.
So we have a motion on the floor to
Deny both licenses.
both licenses, okay. With the stated corrections that Yurko mentioned.
I'll go ahead and second that motion, sir.
We have a second. I tell you, Mr. Smith, I appreciate the fact that you stated that this is not easy at times for these commissioners, because these are the type of things that kind of keep us up at night. These are the type of things that we know that we're challenged to be able to do. And although we know that we affect lives, we also have to consider the public as a whole. And so, but I appreciate you saying that you realize that. So.
And are there possibilities for, excuse me, the water went down the wrong way. Provisional licenses?
Now, well, let me just do this. We've got a motion on the floor in a second. Let's go ahead and vote here. All in favor signify by saying aye.
Aye.
All those opposed?
No.
Motion carries 4-1. You can get with staff and they can tell you what are the next options. I think that, you know, give it some time. Mr. Denny will be able to apply once again in the future. This doesn't prohibit him from not applying. It just simply means that he's not getting his license right now. So you can get with staff. They'll help you out.
Thank you for your time.
Appreciate you coming in. Yeah, let's go ahead and take a short break, about a 10-minute break.
So good to meet you. That's okay.
We'll now move on to item H4, Philip Wiley. Mr. Sharp.
Mr. Chairman, again, my name is Ken Sharp. I'm an enforcement prosecutor with the Enforcement Division. The respondent in this case is Philip M. Wiley. The department initiated action to revoke the respondent's journeyman electrician's license based on his criminal history. The ALJ recommended suspending his license for 1 year and then reinstating it, but only to allow the respondent to work on commercial or industrial job sites, and then only under the continuous supervision of his employer. Briefly, the facts of the case are as follows. The department issued a journeyman electrician license to the respondent in October of 2009. In August of 2012, he was convicted of the felony offense of evading arrest with a motor vehicle because he fled from police after he and a companion allegedly attempted to buy narcotics at a drugstore with a forged prescription. He was sentenced to 6 years in prison, but the court suspended the sentence. On April 1 of 2014, he was convicted of the offense of, and I quote, lesser included injury to a child, end quote, and sentenced to a 2-year prison term. The respondent renewed the license on February 27 of 2012 and again on April 15 of 2014. Now, in spite of his convictions on his renewal application, the respondent answered no to the criminal history question. When confronted with his answer at the hearing, he admitted that he had intentionally falsified his answer on that application. Now, this case first came before this commission on September 9th of last year. The department recommended the revocation of the respondent's license based on his criminal history and falsification of his application for renewal. The respondent argued that he was rehabilitated and urged the commission to reject the PFD and allow him to remain licensed. The commission, as you might recall, or some of you may recall, debated this case extensively, with some commissioners apparently favoring revocation, but not a probated revocation without conditions, since that has no real effect, because if the respondent did commit any violations during the probationary period, the department would have no way of discovering it or doing anything about it until the renewal process. And then it would proceed the same as it would with any other license, as if there had been no probated revocation. There were other commissioners who seemed to lean toward some type of supervised and restricted licensure, possibly with the requirement of having the respondent's employer present at the commission meeting to verify the employer's ability to comply with any monitoring requirements imposed by the commission. After reaching no resolution, the commission passed this case to a future date and directed that in the meantime, the parties should see if they could work out some type of resolution. The department and counsel for the respondent negotiated and reached an agreement on terms the parties believed would serve as a suitable basis for disposition of this case if the commissioners were to find those terms acceptable. And at the meeting on January 6th, the parties presented a proposal for an agreed probated revocation that would have allowed Mr. Wiley to work under the conditions promised by his employer, but would have required him to submit regular reports and verification to the department to ensure compliance. Now, the proposal included strict and immediate enforcement provisions should Mr. Wiley fail to abide by the conditions. At that time, the commission expressed concerns that the plan would require monitoring that might exceed the capabilities of resources available to the department. Mr. Wiley's attorney at that time was not present because of illness, and so the commission, properly reluctant to reject the agreement outright and fashion a different resolution without participation of counsel, postponed the case to today's meeting. Now, if the commission is not inclined to accept and implement the agreement reached by the parties, and I kind of got the sense that that was the case from the last time we were here, then the department maintains its original position that the commission should reject the PFD to the extent it recommends a license suspension and instead invoke a license revocation. And by now you probably know this case as well as I do, but if you do have any questions, I'll be glad to answer those.
Any questions for Mr. Sharp? We have Charles Sechting.
Yes, sir.
So I'm glad you put that parentheses there. That helped me to be able to pronounce your name correctly.
At age 65, I've learned that it's just easier to tell them than try to have them go through it.
Yeah, well, you got to try mine.
Harris Mendez.
There you go. And Mr. Wiley. So I assume you're not going to be speaking because I don't have one on you. Okay.
She completed a late statement that she might, if you have any questions. Catherine is my associate, and she may have some information that would be helpful.
As you know,
yes,
you
sir.
simply can only take in, well, it's kind of a unique deal. I'm going to go through the spiel anyway. What was presented in the hearing I know that since then, there's been conversation back and forth about the plan that's been submitted.
Yes, sir.
So there may be some conversation on that one too, which I know is outside the scope of the hearing, but it was kind of the direction of the commission to lead you on that path also, so.
Yes, sir.
If you don't mind, just state your name for the record.
My name is Charles Sechting, Soechting.
Go right ahead, sir.
And what I have is something I prepared, but I previously showed Mr. Sharp, but it's a timeline of events for you, and I believe he has no objection to it. It just properly summarizes where we have been within the hearings and within boundaries of this hearing. So you don't have to try to pull back from the stretches of your memory those things that we have all forgotten. You know, oh, I'm sorry. One of the things I think is very important is that recognizing the subject matter of what we're here talking about. As Mr. Sharp and I have both talked about the fact that I've been practicing 35 years, these are the kind of cases, these are the kind of subjects that we are very uncomfortable talking about because it's such a troublesome thing. And I will tell you, so that you'll understand, I took this case only after I was convinced that he was charged with a crime he did not commit. And that is very important because it involves a sexual assault of a minor child that did not occur. That's why that case was dismissed. I was the attorney along with Catherine Sullivan. But the simple fact is, and it happened for a very simple reason. It couldn't have happened, and once the first lawyer had sat on the case, sat on it, and done nothing but take money and done nothing. Once they told me the facts, I said it couldn't have happened because there was a drought that year. Couldn't have happened.
This is in the record.
Okay,
I
let's
think
go ahead and
it's
move
well,
on into
it helps you understand that what he pled to was spanking a child, and he did spank that child, and he understands that was wrong. But in the meantime, some of the best things happen out of some of the worst things in our life. He sat in a jail for a year. During that period of time, as you'll see, and once we found out and were hired, he was out of that jail within about a year with a resolution to the only charge that really mattered. He immediately went into Narcotics Anonymous, and he's still active in it today. He's had the best support system. His family is sitting here, his father, stepmother, and mother on the second row to my right, and they have been entirely supportive of him every step of the way. He has a wife, 2 small children who can't be here. The children shouldn't have been here anyway because one of them's pretty noisy, but shouldn't be here because it's not appropriate. But one of them is sick and the wife is caring for that child. This man has done as good a job as anybody I've ever seen at putting his life back together and getting on with the business that he has been trained to do. He wants to work as an electrician. I think the conversations between Mr. Sharp and Ms. Sullivan have been very productive, very telling, and kind of recognizing the fact, as the gentleman said before us, and I feel terrible going right behind someone who just got revoked or denied, but it's one of those things that happens. Every case is different. In this case, the case he was charged with, he wasn't guilty of that. He took responsibility for what he did, got his 2 years credit for time served. He was out and back to work. It's hard to believe, but he was back to work the very next day. Now, it gets us to the question, as he admitted that he falsified or gave the wrong answer. As he testified at the hearing, it's a yes-no online application, and he did not believe that either answer was correct, but he put no, which was definitely a wrong answer. Wrong answer. But he has accepted responsibility for what he's done and gone back to work and done everything that he ought to do. If you look at the timeline of events, every person that has supervised him in these cases, and as the ALJ judge found, every person that's been involved has cleared him to get back to the business of being a citizen. He was discharged early in every instance because, and as it was the testimony, you find it section C where it talks about evidence of the judge's findings. Couldn't have been going through a harder time in his life. His brother had taken his life, died from drugs, essentially. Do we need to wait for Mr. Arismendi to come back, or can y'all?
We can go. Keep going. We can go.
Okay, good. There he is. I thought you'd got tired of listening and just left. You do. It was a bad time in his life, but the judge says there is ample evidence, and there really was ample evidence of the hearing of a life turned around and going in the right direction. Mr. Wiley recognizes that you just can't say, though, you're free to go do whatever you want to do. He's willing to live by the conditions that you're going to impose upon him, and those conditions are that, you know, the industrial, the commercial, no children under age 18. And this is the child that he allegedly caused injury to, and I think that was a stretch, but in the criminal justice system, that's how things work. She was a troublesome child anyway, but that's not a good excuse. But
It's also not in the record.
Yeah, let's keep it to just what's in the record, please.
I can't say it was or wasn't, but I think that's a fact well known to everyone involved in this case. It's actually a niece, and I know that is in the record. But in any event, this man has made that turnaround, and you people as serving as commissioners, I can't even begin to imagine the kind of decisions you have to make. It's not in the record, but I formerly served as a county court at law judge in Houston, and I was a visiting judge, they called it, and I had to make decisions that I knew affected people's lives. In this case, no one is going to be affected by his return to his business that he's trained for. No one has ever been affected, except Philip affected his family and his life more than anyone else. He made a bunch of wrong decisions at an early age, but as you remember, and I know this was in the record, Mike Rose, his employer, said they wish to assist Philip, and y'all had this record in the previous transcript, they want to assist Philip in any way they can in his current journeyman's license, and they want to keep it in good standing, that they're going to supervise him. They'll do anything you want, because there's nothing you can ask of Philip that he hasn't already asked of himself. I'm a proud parent of 4, a Marine colonel, a lawyer, and 2 daughters that are very successful going to college. I wish they'd finish. But, you know, we have expectations for our kids. And I can tell you that I think his folks sit out here today, if they were to testify to you, they would tell you, as evidenced in the order from the judge, that there's ample evidence that he has turned his life around and he is doing the right thing. Tell us what we can answer you in the way of questions that will help you make a decision that benefits his wife, his children, his parents, himself, and society, because there's nobody reaching out and saying society has been a victim. Philip has abused his own life, and he's made reparations, and he wants to get on about the business of being a licensed electrician, regulated by your commission, and doing the things he's supposed to do.
Any questions?
I can tell you one question I would ask me if I were y'all. Would you trust him to come in your house when your daughters are there alone and work on your things? And I would say absolutely. That's how well I've come to know him. And I wouldn't tell you that as a former highway patrolman and as a naval officer myself. I wouldn't tell you that if I did not believe it.
And that recommendation also was not in the record.
That's true. But I want to note he was smiling when he said it, so. You know, this is one of those strange things. I'm asking you to do something you don't want to do or naturally not inclined to do, but is the right thing to do, both by yourselves and by society and by Philip. Philip spent 356 days in jail for a crime he didn't commit, but it was a good thing for him. He'll be the first one to tell you that if you ask him, that nothing better could have happened to him in his life than happened to him at that time, in a strange way.
Mr. Wiley, did you care to say anything?
You need to.
I just handed him the mic. Of course, you can only state what was in the hearing that was presented, and confine your comments to just that. Also, and go ahead and state your name for the record if you don't mind.
My name is Philip Wiley.
Go right ahead.
I just, you know, this turn of events that has happened has turned my life around to the point where it, like you said, the year in jail, it's a wake-up call, and it allows you to reflect on your life and all the wrongdoings, and it allows you to learn that you don't have to live that way. I do not have to live that way, and I can keep moving forward, and that I am a trustworthy human being, and that I am not a threat to society, and that my family depends on me, most importantly. And, you know, I mean, I don't know, that's pretty much all. I'm doing as best I can, and I hope that the decision y'all make is the right one.
I have a question for you, Mr. Wiley. The application, when asked if you have pled guilty or no contest, your attorney stated that you were confused by the question. What was confusing about it?
How to explain it?
Yeah, but it was a yes or no question.
I made a mistake. I acknowledge that.
So was there confusion?
I should have answered yes. I know that today. But these are the things that I'm learning over time that has to change my life. And when at that present time, I was confused about how to answer it and I didn't know how to explain it, so I answered no. But I mean, those are just excuses.
How did you plead to the offense of evading arrest?
It was probation.
I know, but how did you plead?
I think it was guilty, yeah.
So I go back to the question. When it asked you if you pled guilty, yes or no?
At that time, I was on deferred adjudication, and I did not have to put that. But at the time when I answered no, I acknowledge I should have said yes. You know, I mean.
I'm thinking I wasn't the original attorney, but I did handle that matter. And now this is just, I can't swear I'm right, but I'm pretty sure I'm right. And they did not use that as a basis for revocation. Instead, allowed him to successfully complete, have the deferred, I believe. And that was because, as I said earlier, the underlying case stunk down in San Marcos, and we got it resolved. But I'm almost dead certain that we had a successful resolution to the evading as far as dismissing the deferred early with an early termination. Does that help explain? It was just, well, sometimes you get cases that stink, and this one stunk.
Oh, trust me, we know that.
Okay.
Any questions for Mr. Sickings or Mr. Mr. Wiley, I'm sorry. Yes, Mr. Shaw.
There's a mention of a agreed order, and I just want to ask the staff how that would impact workload or impact the enforcement of that agreed order. Mr. Bryan, Mr. Kuntz?
It's outside the model, and so it's going to take a little additional effort. Enforcement's going to have to be on top of it to monitor if there's reports and that requirement. If this is something that becomes habit, it's going to strain the system. There's no question about that. It's one-offs or something maybe we can absorb, but it's not. It's definitely outside of the model.
Thank you, sir. I may have other questions in a minute.
Commissioner Shaw, just to add one more thing. The staff has a full workload just keeping up with collecting the penalties that have been assessed in the cases. And it's a constant workload to do that. But then to add this on, it really puts a burden on the staff.
And I remember in our September meeting that was the wish of the commission as a whole. I kind of, I'll state now what I stated then. I think it's in the September meeting, yes. I think it's going to be virtually impossible to do this. I mean, you've outlined a 24-point plan, which I think that 90% of it is just unreasonable. I don't see how the department can do it. I just don't. I think it's too burdensome. I think it places responsibility upon this department that we're just not set up for. So although I know that each side went through great lengths to get this because the commission requested it from you, I just don't see that, I just have a hard time thinking that this plan can even be put in place. I mean, that's just my opinion. I voiced it then, I voiced it now, but I know that the commission as a whole wanted to be able to get something put together.
Ma'am?
And I know that you all did it in great faith in doing that. And now it's presented back before us again.
May I respond with one response? The initial recommendation, I believe, by the administrative law judge was to be suspended for 1 year. Since that period of time, he's renewed 2014, 2015, I believe, and now coming up on 2016. At some point in time, you know, he has really made a real effort to turn his life around and has done a good job of it. And I understand the constraints of state funds. I was a highway patrolman long enough to understand that there were times there just wasn't money to do things. But someone said, I think it was Mr. Francis, that this was a one-off model. And I ask you, is there a way that you get him to make an agreement with you? An agreement with you, much like when I was both a Navy prosecutor, when I was a lawyer for the last 35 years. God, that's been a long time. But make an agreement with him that he will surrender his license. He'll surrender it voluntarily without any questions asked if there is a criminal offense in his future. And I think that's a fair recommendation for a period of time until he's adequately established, because right now, if you don't give it back to him, you know, these people go right back to having to be on public assistance. They go right back to the things that caused crime to happen in the first place. And maybe I'm a guy looking at life through rose-colored glasses, but if we don't stop saying we can't do it because it's too hard, we'll never, ever change the way society looks and the way we are as a community. It's never going to happen. And I think the older I get, the more I realize that by being hard when we're young, we're not being good. And this is not something, you started with a prayer. Mr. Smith even referenced that. And I'm going to tell you, the first one that would have given him a break would be Jesus. And he really would, because he hung out with prostitutes, sinners, and all kinds of people. And this is a man that has changed his life. And I'm just asking for some assistance in letting him go forward with his license, with his training, with his life. Yes, sir. Mr. Shaw.
Go ahead.
First of all, I see 20 listed items on the order, not 24. So am I missing something?
Real correct.
I haven't looked in a while, but there may be 20 or 24. I thought we had it distilled down to about 20, but
And it may be 20. I was just thinking there was 24.
but it's in that neighborhood. And I did acknowledge that in one of those meetings, I guess it was in January, that there was quite a bit here, and that it did stand to consider a significant possibility of straining the resources that we had. That it's not something that we could do all the time if we could do it this time, and we didn't know.
No, I appreciate that. I just wanted to make sure there was a clarification that I did not miss anything, that my count is the same as your count. Maybe we didn't go to the same math school, but I see 20 instead of 24.
Well, and I can look that up and see
Having
what I
said
have.
that, I'm a little confused, and I'm not an attorney, but I'm surprised that you all had so much, so much writing on this, when there's only a simple answer to this. And that is, if there were to be an agreed order, and that is if there were any violations, if there were any criminal violations, the license would be suspended indefinitely, period. That's how I see it. I don't see 20 different, to me, it seems like you're writing the same items over and over again. So.
Well, I can tell you, having worked in drafting contracts and wills, estates, and trusts, that there is a purpose behind each and every one of those that is separate and distinct from all the others.
And this covers even a deferred adjudication, meaning something to lead to a dismissal. If he's charged, convicted, or received deferred, he's out of there. I'm just saying, and I don't know, I guess I'm not real good at begging, but I am begging. And I'm telling you, 99 times out of 100, I would not have taken this case, except sitting and talking to the family and getting to understand that someone, a member of our profession, took a lot of money, did no work, and let a man sit there, but yet, by God's will, it all worked out because he found the right way to live after that. And now he wants to go back to work and do a good job.
Well, and I tell you that the AOJ also stated that not enough time has elapsed since the falsification of the application.
And now a couple of years have passed.
And so I guess that begs the next question. In the event, and I'm going to probably get this from staff, in the event that we deny the application, of course, they always have the opportunity to be able to apply later. At what
Yeah.
point in time does it date it back to? Is it effective today, or is it dated back? Which, I guess the question I'm asking, because you're right, it has been, what, a couple of years?
2 years, within a
And
couple
at
of
what
weeks.
point in time would Mr. Wiley be able to apply?
This is Brad Bowman, General Counsel. I think if you're talking about a revocation of the license, there is a 1-year period before which he could apply again. And I think that would start when the order is final and when the revocation actually goes into effect. So it wouldn't be today necessarily, it would be, you know, there's appeal times have to
Right.
run and things like that. So there's some weeks built into that. But,
Okay. That answers my question.
Would it appear, the fact that, I mean, I know the hearing was a year ago, and then, I mean, this time, government moves slow. I think it was a year ago, about a year ago, right now, March 31, I believe. Could the commission take that matter into consideration when rendering its opinion so as to, you know, the one thing, if something bad happens, I'll never have an ounce of credibility with you again. Never. And he'll never have
You're an
any
attorney,
credit.
Why would I not?
Well, you know what? As I tell people, I'm a fifth-generation German living within 5 miles where my family's lived since 1852, and you can't live in a small town, be a highway patrolman, a naval officer, and get along good in the community and tell lies.
Well, I tell you, I've got darting eyes in the back of all the attorneys looking at me. Commissioner Shaw.
Back to the point, I'm just going to make some comments to the commission. Here's what I'm seeing. The application was made almost 2 years ago. Or the falsification on that application was made almost 2 years ago. So how much more time is necessary? The second thing that I see is, based on the presentations that were made, we did request that the two attorneys go back out and look at the agreed order. We did have them go out and work those out. While I disagree that there's 20 different items in here that some have relevance, some don't, putting the commission and the staff in a workload issue where there's so much now that we have to monitor over the next year. I wish we could have gone back in and taken some of these items out so that they would have been self-propelling itself, or maybe working themselves out, with the applicant himself. But with that, I just think that we did ask these two folks to go out and work these things out. So this is what I see here, and how much more time would we want to give if we were to deny this PFD?
Well, I think that the discussion at that point in time was we had commissioners that were interested in developing a plan that would allow some type of, by some criteria, which would require also that the employer be able to provide information to us, because I know that Rose Electric glowing, reviews about them. But I think that the conversation, from my opinion, probably moved into a point of saying that there's really no way that we can require an employer to report to us, because that employer is responsible for the employee. It's the license holder who is responsible for that. And I think that was where I was coming from, was that it was going to be difficult for the employer to be able to do anything. We couldn't require that the employer do anything. So I think Commissioner Yurko had a question or a comment.
I actually did, Brett. This is just because of the sheer nature that it's been a couple years since we started this. And if we would have just taken the suspension to begin with, we'd already be done and moved forward. Is there a way to kind of retroactively make this like time served and we're done?
Well, this is Brad Bowman, General Counsel. So the option that, the agreed option that has been worked on is for a probated revocation, I believe, with these terms. So I think that might be what you're talking about is something you could take into account in deciding, do you want to go with that rather than an actual revocation or actual suspension?
Well, I hate to burden the organization to take on the enforcement of the probated terms. And I didn't want to set up, as Commissioner Shaw likes to say, a precedence in that regard. So like Mr. Francis was saying, a one-time shot and that's it, we're done with this. But then I thought, after we brought it up, it's been a couple of years since we started this. Can we just be done with this?
I guess the short answer to that is it's
The will of the
within the
commission.
commission's discretion to decide what you think the appropriate remedy is if you don't want to take any action.
Like, I would like it to be on his file that he did wrong by falsifying on the application. The time has passed, we're moving forward. That's what I was trying to get at, is I don't want to reduce the importance of lessen the importance of the mistake that was made. But
Well-
I don't want to keep perseverating over this whole thing.
One thing about the time passing, there hasn't been any disciplinary action or anything for all of that time. He's had the license and continued working for that time. So I understand you want to take that into account.
Right.
But again, that's just going to come down to how the commissioners will want to decide.
Mr. Shaw. Oh, I'm sorry.
Commissioner Yurko, Brian Francis, you could do a couple of things. You could do a suspension and then probate it immediately. And so that would then fall under our normal probation standards of if you violate the rules and do X, that's within our process to do that. There's no question that this particular case, the commission has wrestled with and struggled with. You've never had any case come back this many times. And I think it's reflective of the process. Mr. Sechting talked about government moving slow. This is actually a slow movement that's been in the benefit of your client because they've been slowly deliberating and working through this issue, trying to come to the best possible conclusion. So slow benefited you this time, so we need you to put that on
Thank
the
you.
billboard. The government went slow for the right reasons. But you could easily do suspension, probate it. You could do a revocation and probate it to make sure that people understand that lying, making a misstatement, omitting something of that nature is a significant issue, and the commission takes that seriously.
Commissioner Shaw.
Yeah, I'll go back in and kind of make this statement. I mean, a couple of things. I see things very objectively, and I think I've put my arms around this. I think part of this whole issue is that had we reacted, say, in 2014, then, like Commissioner Yoko said, we would not even be here today. I think we've belabored this subject to this point, and the commission themselves have asked for us to go in and look at the agreed order. Having said that, I think, based on what has been presented to us, I think it behooves me and probably the whole commission that we rethink this whole agreed order issue and maybe go the route of either, probated revocation and reinstatement, instead of having to put the commission to go out there and make sure that all those 20 items are measured over a period of time. I'm more concerned about the amount of work that we're putting
I agree.
on the, staff. So.
I agree. I think that's my concern also is that, and that's why I made the statement, I think it's going to be very difficult to look at that 20-point plan, correction from 24, thank you, 20-point plan and be able to say that this is where we're at and and making sure that we're doing that, because it can be a lot of work for the commission. I tell you that and I'll be, again, I think you probably realize I'm brutally honest. I have an issue with the fact that you lied on the application, knowingly. There was no confusion. I would basically say that while we try to say there was confusion, there was no confusion. It was a yes or no answer. In trying to say you don't know how to explain it, from what I can see here, there was really no attempt to try to do that in the initial. You simply said no. And so that's an issue for me, because I think it does go back to the trustworthiness, honesty, integrity, which is what we look for. There's still the fact of as you fought for the lesser charge, But it's still out there, the lesser included injury to a child, which is a third-degree felony. That was there, and I think you fought to bring it down, which you did. So, I mean, I think you commend your attorney for that, but that's still out there. So whether, I think that our first question is, do we want to look at a license, granting or not? And then the second point that we'd have to figure out is in what basis would we do that? You know, the probated revocation or suspension, or how we do that. I think that those are the, in my opinion, the second one. The first one is do we even want to consider a license to be granted? So I can tell you that from my standpoint, that's where I'm at. It's a fact that you knowingly lied on that application. And then we still have the conviction of the injury to a child. So, any other comments or questions?
Of course, you can't open any kind of evidence into what the facts of that case were.
Right.
And,
But you're not going to, right?
well, no, I'm not. But whenever you don't get a fine or anything, you know, it's a pretty good indication, well, you just plead and take credit for time you were in the jail. Pretty good indication it wasn't a case to start with. But everybody in the criminal justice system in this country hurts because it's understaffed, overworked, and just overburdened in so many ways. And that's how you clear jails out. And when someone makes you an offer like that, you take it. But the simple fact is, and I can't tell you anything, but if I were to sit down and tell you afterwards when this hearing is over with, you'd say, oh my God, this family almost got bankrupted by their first lawyer before we got involved.
I'm sorry, but I think we're
That's
really
outside the
veering
record,
off.
I know, you're
So,
right.
Any other questions? Well, any other questions for Mr. Sechting, Mr. Wiley, or Mr. Sharp? Because if not, I'm going to close it off.
Can I make a motion?
Let's go ahead and let's go ahead and stop. You guys can go back
I
and
think
sit
for-
down if you like.
Oh, thanks,
Appreciate
sir.
it.
Brett, I'm gonna just give it a shot, and Brad, you can advise me if I'm doing it the wrong way. And then if it works, we'll vote on it, and if we don't have it, someone else can give it a better shot. Okay, I would move to suspend the license, but move to amend the PFD to probate the suspension for 1 year, assuming that would provide him the opportunity to continue working during that suspension.
And this is Brad Bowman. The only thing I would add to that is what terms and conditions you want for the term of probation. Brian kind of made the suggestion that to keep it simple, I think is where we're going with
Yes.
that, rather than the 20
Yes.
items, and it would be, you know, no further criminal offenses and complying with all of the laws and rules of the department, kind of our standard.
Which is our standard for
terms.
every, right. And to reflect, I appreciate Mr. Sharp making the effort to try to make this work and being very flexible with the commission's moving
And then
desires.
one other item, do you want to limit or restrict work to commercial or industrial sites?
Is that even enforceable?
Well,
That was my concern, what I was trying to get at to move this forward, since it has been a couple years since, that if that's not even really enforceable, I don't want to put on a burden that can't.
May I offer something on that?
Uh-huh.
That the requirement is that the employer limit the individual to commercial sites.
Well-
If the employer does not, if there's a violation of that, then I'd like to bring an action against the employer for failure to honor the commitment.
Well, I understand that, but I don't know if we have standing to do that, since he's really not a party to the action. Would it not be better to put the burden on the employee to make sure that we do not find that he is ever in a residential?
That gets down to self-reporting.
No, I understand,
What
but-
if we required a contract between the employer and the agency?
I think it just goes to keeping this thing going on for another meeting.
Okay. I'll quit.
Can the employee agree to those conditions?
No,
Well,
I just think we need to resolve this. Well, anyway.
Yeah.
We were
there's a
chatting
motion.
about that.
As a condition of probation, I meant.
Just a moment.
There's a motion, I would like to make that friendly amendment, if it's possible, to the motion maker, to at least add that if there were any criminal convictions or activity, then maybe the revocation falls in place.
Well, that's what it would be, because it's
That
probated.
would be one of the
Okay.
terms.
I'm going out of the limb and making a second on this one, and I hope you understand, sir, that this is something that, you know, as you mentioned, this sets, I hate to set a precedence to anything. And while I think we've kind of worked around this issue, I think you've given the ample time, I think from April till April this year, 2 years, had we reacted on this, we ourselves have asked to go and put the agreed order in there, so I'm wholeheartedly.
So we have a motion and a second. Any further discussion? All in favor signify by saying aye.
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 Those opposed?
No.
Can we get a vote, please?
Luann Morgan,
No.
Catherine Rodwald,
Aye.
Ravi Shaw,
Aye.
Deborah Yurko,
Aye.
Mike Harris Mendez.
No. Motion passes 3-2. So staff will get with you and let you know what you can do in the next one.
Thank you so much for your time.
Appreciate it. Thank you. Let's move on to item 5, Dean Perriott. Mr. Sharp.
Thank you so much. Nice to see you.
Catherine?
I was just saying, I was South Texas.
Let's go ahead and keep on with our meeting. My apologies. Yeah. Mr. Sharp.
Good morning.
Go ahead, Mr. Sharp.
Thank you, Mr. Chairman. Ken Sharp, Enforcement Division. Our next applicant here is Mr. Dean Perrott. The department proposes the denial of his apprentice electrician license application. The department issued an apprentice electrician license to Mr. Perrott, the applicant in this case, in 2007. In 2013, that license expired. It was 2013. Now, about 2 years later, in March of 2015, the applicant filed a new apprentice electrician license application. This is Mr. Perrott's criminal history. In 1985, he pled guilty to felony theft. The court deferred adjudication and placed the applicant on community supervision for 3 years. Mr. Perrott said he was not really guilty, but had just been young and dumb and made a stupid mistake. In 1986, the applicant was convicted of possession of marijuana and sentenced to 3 days confinement in the Harris County Jail. Now, he said he was not really guilty, but he was just a victim of circumstances. In 1988, the applicant was convicted of burglary of a motor vehicle with intent to commit theft. In that case, the court gave him a 1-year county jail sentence. And again, Mr. Perrott testified that he was just an innocent victim of circumstances in that case. In 1989, Mr. Perrott was convicted of criminal trespass and sentenced to 20 days in jail. He explained that conviction at the hearing by saying he was an innocent victim of circumstances, that he had done nothing wrong. When we moved from 1989 to 1996, when the applicant was convicted of aggravated assault and sentenced to 10 years in prison, the court suspended the sentence and instead ordered him to serve 90 days in the Harris County Jail and then placed him on community supervision for a period of 10 years. The indictment in that case indicated Mr. Perrott shot a man while robbing him. Those are the official court records. Mr. Perrott had several different explanations for this charge, including an account of a dice game in which someone else shot the victim, but Mr. Perrott got the blame for it. On March 27 of 2014, the applicant pled guilty to the offense of aggravated assault with a deadly weapon. The court found that the evidence substantiated the applicant's guilt, but deferred adjudicating him and instead placed him on community supervision for a period of 6 years. According to court records, Mr. Perrott had come home one day and found his adult daughter in the company of a young man in what Mr. Perrott described as, or at least perceived as, a compromising situation. Although at first the applicant told the man he had 2 minutes to leave his house, he apparently became impatient, got a rifle, and shot at or in the direction of the young man as the young man ran away. The applicant then chased the young man in his truck as the young fellow ran through the neighborhood. The young man climbed fences and took other evasive action and was finally able to escape the applicant's wrath with the help of a neighboring homeowner. In his testimony at the hearing, Mr. Perrott downplayed the charge and claimed he had not really done anything wrong. He explained the incident differently, depending on the cross-examination question asked. But his two basic explanations were first that he had merely fired a shot into the air as the young man ran out of the house. A version he later changed to say that he fired a shot in the opposite direction of the young man as the young man charged at him inside the house. Now, the department's guidelines for criminal convictions for electricians include crimes against property, such as theft or burglary, and crimes against the person, such as assault. Mr. Pratt has convictions for crimes that fit into both of those categories, and the ALJ concluded his most recent deferred adjudication for aggravated assault with a deadly weapon should be treated as a conviction. We also have the honesty, trustworthiness, and integrity standard, and judging by Mr. Pratt's multiple claims of being an innocent victim of circumstances and having never really ever done anything wrong, well, under that standard, he falls short. The ALJ recommended that you deny the license application. The department recommends you adopt the PFD as amended after the department's exceptions. Thank you.
Any questions for Mr. Sharp?
I have one.
Yes.
The information we have shows in March of 2015 another offense?
No.
I think the last one you described was March of 2014.
That's the last one.
And then this
I
one
have.
shows March 8th of 2015, net theft, felony theft.
I'm not sure what that is. I don't
That's
have
not a
it.
typo?
I don't have a record on that.
Maybe a typo. Maybe it should be March 2014, I believe.
Yeah.
I think that's an
It's just
error.
on the-
Is that just a typo?
Okay.
Yeah.
Any other questions for Mr. Sharp? I've got four public comment forms. Dean Peratt, I believe.
That's correct, Dean Pratt.
Terry Peratt, Pamela Garrett, and Daishanika Garrett. Okay. I'll just kind of let you all know, at this point in time, the only thing the commission can take in consideration were those testimony and those items that were presented at the hearing. So anything outside the scope of that, we'll ask you to not say it and be able to, only be able to talk about what was there at that time. So I'm assuming that y'all were all at the hearing? Who was at the hearing?
Just myself.
Okay. I can tell you that if you want to speak, you can, but it's going to be very difficult to you talk about something that you were not at. So, okay, so it's going to be, I'll give you opportunity, but just so you know, we can only confine it to what was at the hearing itself. Okay? So, Mr. Peratt, I'll go ahead and let you start. If you don't mind, just state your name for the record.
Dean Antonio Peratt.
Go right ahead, sir.
Well, first of all, I want to express my deepest sincerity and for my remorse of my past record. All of those things that had happened was prior to when I was in high school. Still in 86, 89, I was in college. Okay? Those are old. Yes, I did serve some time in prison back in 1999. While I was in prison, I was evaluated my life and made a decision, is this the life I want to live? At the same time, it was the 9/11. I really looked at my life and worried about, wow, people lost their family and loved one, that I need to be out there to take care of my family. During that time when I was released in 2001, I went to work. I went straight to work as an electrician with the same very company that I had got arrested back. I went back to work with them. At that time, I was working consistently. I bought my first house in 2004. I went to work with Big Brothers of America, and if you're familiar with those, it's NSA. Worked with them with a private company throughout the United States traveling. I came back home, and my wife and I bought a second house. I worked constantly to provide for my family during those times. Prior to that, there was no other incidents other than the incident that took place with my daughter at my own house, at my own place of residence. This is my daughter here. I want to say I apologize to her. She has been moved back into the house. On this day this incident took place, I came home from work. I owned a place of business. I've been robbed at, looked at the barrel of a gun at my own place of business. I came home. My daughter was acting kind of nervous. I assumed something was wrong, okay? And then at the time she did not tell me the young man was in the house. I did not know the young man at the time. To this day, I do. that is her boyfriend. Yes, I pleaded to the case. I received 6 years probation, deferred adjudication for that there. I finished my my community service. I was not sentenced to no classes or nothing like that. The judge felt like I didn't require no type of counseling or any of that nature. On my application, I submitted on my application at the time that yes, I did have a charge, a felony charge on my application for renewal of my electrical license. Not once did I lie on nothing. I told the honest truth. So I'm here today. Excuse me.
Take your time.
Excuse me. I'm here today to tell the commissioners that I have changed. I have changed so much. I help people in my community constantly for no charge. I go to church. I've been rebaptized in June of 2010. I had committed my life to church and my family first. Okay, those are the things that I do. I am 49 years of age. These things happened way back in 89, 86. I was young and dumb. I admitted to those things, just being around the wrong type of people at the time. You know, just trying to be cool. I accepted charges for someone just because you didn't want to be a certain outcast, which was wrong. So I accept my responsibility. But I do say I have kids. I have 6 kids that I have to provide to. This is my youngest son, Dylan Peratt, that is still in school. I have a daughter in college, and I have other kids that I have to provide for and help. I have to pay child support. And because my income have changed drastically, I'm no longer the man I was. I have to rely on other people, which I don't think is right. I'm the man of the house. So I'm asking for the state to renew my license. My daughter would like to say something.
Any questions for Mr. Peratt? Again, as I mentioned, if you feel that there's something that you would like to add that was in the testimony at the hearing, feel free to do so. You tell me whether you're going to be able to or not. Neither one, you weren't there. Okay. So I'm just going to scratch through and just know that you're present with him. The record will show that you're with Mr. Peratt, is what it'll show. Mr. Peratt, I can tell you that I think it's commendable, the changes that you've made. I can see it. But what I show here is a case that took place in 85, 86, 88, 89, 96, and 2014.
2014? That's when I received deferred adjudication in 2014. There was
Right.
no other case.
And you pled guilty.
Yes, I pled guilty to the only case since I got released from prison that was involved with my daughter here, sir.
Right. And then you were convicted of aggravated assault in February 23rd of 1996?
96? Yes, that's I went to prison for that case. I violated my probation.
And then you were convicted of an offense in 89? And then which ones are you talking about, as you said, as you were young? So, I mean, right now, I'm showing 5 cases against you?
That's correct, yes.
You were released when?
2001.
I'm sorry, from the...
From the 96 probation violation, I did 4.5 years in prison. I came home October 1st, 2009,
Okay.
right after the 9/11, and that's when I made a change. Been working ever since, owned a business. I worked have 2 houses, just working constantly. And I have not been in trouble prior to this time that had happened. I could tell you about the case of my daughter, Can. Reason why I accepted the probation, because it's not admission to my guilt, is because of my past history and dealing with the district attorney in the state. They do not play with someone that have a prior offense. They want to throw the book at you. And I did not have the money and the funds to go all the way with it. And so I figured at that time that, hey, I'm at this age that I am right now. I'm more mature, I'm not getting in no more trouble. I don't want to get in no trouble. That's not the way I had lived since the time I got released from prison. Just that one incident that wasn't right. And I have apologized consistently about it, and I regret.
Any questions for Mr. Brock? Any other questions for Mr. Sharp? Thank you. You can go and have your seat. Commissioners? Comments, motion?
Well, I don't feel like he's a threat. I feel like he's trustworthy, and,
Sir, I do have letters from my probation officer.
No, we're good. Thank you. Appreciate it.
and, I'm willing to give it a try.
As am
I would like to, I would need help with, which, item to, amend, but, I think we could still do a suspension and revocation and, for a year and give it a try and see if, especially with an apprentice license, because I think an apprentice license, you're pretty supervised. And, so I'd like to make a motion.
This is Brad Bowman.
Uh-huh.
Commissioner Morgan, this is I believe this is an application for a
For a
new
new
license.
license. Would have to be a
Oh,
conditional.
So there's not the opportunity to probate,
Oh,
or
there's not?
suspend, or revoke and then probate it. There's only the provisional license, the
Okay.
6-month provisional license that we've talked about before. We haven't actually issued one of those before. If you wanted to issue the license, that would be changing, if you disagree with the judge's analysis on
Mhm.
that'd be changing conclusion of law number 7, I believe, is the only.
Number 7?
I apologize. Also, findings of fact 10, which has to do with, it's not really a true finding of fact, it has to do with the, whether he meets the legal standard of honesty, trustworthiness, and integrity. And I believe
Yeah.
that would be it.
Okay. Okay, and we can go ahead and issue the license?
If that's
So
your,
it would be,
your
you said a
motion,
provisional license would be like a 6-month?
The provisional license is that's a provision in Chapter 53, and it's a 6-month license that has terms that are in the statute. I don't recall offhand what those terms are. I think it's to not committing any further offenses during that 6-month window. Again, the department has not issued one of those licenses previously, but if that's the commission's, I know the commission has considered that in cases before.
Can I ask something? Is that a new provision that we've just put into play?
No, it's been there for a couple of legislative sessions, maybe. It was added to the law as a...
We just haven't done one yet.
Right, and it's typically for, in Chapter 53, it's there for offenses that don't fall into any of the categories that agencies can deny the license for. But if the agency, so the agency either has to issue the license in that situation, or you can issue this provisional license. That's part of the reason we haven't made use of it before, but the SOA judges have in some cases recommended a provisional license, even if it's a offense that you could deny for, like this one, like these offenses. So it's an option for you to do that.
And Mr. Chairman, Brian Francis, just to kind of add to what Brad was saying, the reason why we've not taken that position before is that we've only had our criminal conviction provisions look at the things that we would revoke a license for. This says if it's outside of that path, then you could also do it here. But there are other elements that are tied to it. It's looking at probationary reports, looking at the documents that you get from the parole office. And so we were saying, if we're going to look at the things that we can deny or revoke a license for, and we're going to grant it, then let's just give them the full license. Let's don't create an alternative path for, again, another one-off. That's why historically we've not done that.
Commissioner Shaw.
So maybe this is a question for Mr. Sharp. And before anybody makes a motion on this, I just wanted to make sure that I understood, so that I can vote appropriately. Mr. Perot held an apprentice license which expired in 2013.
That's right.
He made a new application, an application for a new apprentice license,
In 2015.
the same license he held before.
Yes, sir.
Was the application completed accurately?
Yes. Well, to the extent that he answered yes to the criminal history question.
Thank you.
In my understanding, then we gave it to him back then?
Not in 2015. That's the
But we
license.
did in 2013.
Well, he had had it up until 2013, and then in the latter part of 2013, I think it was August 2013, is when he had the incident where he shot at the guy in his house. And then when he had some problems there that he dealt with, and then came back in 2015 to apply for the license again.
Any more questions?
Okay, well, I'd like to go ahead and make a motion that we issue, and I'm debating on the provisional license, but, with provisional license, we would go back and review it after 6 months, is that correct, or?
Well, it's automatic at the end of the 6 months that he would get the full license unless there has been a violation of the terms during that 6 months.
Okay, so we'd be reviewing it then again at 6 months?
We haven't done one of these before,
Okay.
so I don't know that we really have a procedure for that, and maybe,
So should we just go
enforcing
back,
it-
so we should just go back with a 1-year license then? I mean, tell me what,
That's the approach we've had, because you're looking at a criminal conviction that you would normally either issue or deny on.
Okay.
That provisional license provision says you're looking at criminal convictions that you typically wouldn't deny a license on. Now you're saying, I'm going to deny it, and let's give them a provisional. So you're really going through your normal analysis of, you've weighed the facts, you've looked at the issue, give them the full license or not.
Okay.
That's what's before you, and that's why we've
Okay.
taken it, because these are normally in your purview. This is not something you would normally not consider.
okay, so I make a motion that we issue the license, and adjust the conclusion of law number 7 and the finding of fact number 10, is that correct? Okay.
Second.
We have a motion and a second. Any further discussion? I can tell you that I think I would have been in support of it had we not had another recent attempt or another recent charge. When I go back and say 96, and if nothing had happened since 96, I would have been okay with it. But we've had another charge since then. And that's an issue for me. And so I can tell you I'll be voting no on the motion. Further comments? Let's go ahead and vote. All those in favor of the motion as presented, signify by saying aye.
Aye.
Those opposed? No. Motion carries 4-1. So you're going to be receiving provisional license, and the staff will get with you, and you can talk about it. Let's move on to item number 6, Terrence Edwards. Mr. Rennick.
Commissioners, Robert Rennick from the Enforcement Division. This respondent seeks to renew his Class A barber license. The ALJ recommends that you deny the renewal and revoke the license. Between 1997 and 2002, the respondent was convicted of 6 crimes, including 2 possessions of marijuana, 2 possessions of cocaine, 1 unlawfully carrying of a weapon, and 1 attempted tampering with evidence. In 2002, the respondent was sentenced to prison for 4 years for 1 of those cocaine possession cases. He was released from prison in 2006. In 2009, the department took a chance on the respondent in spite of his long criminal history and issued him his Class A barber license. Then on April 29th of 2013, while licensed by the department, the respondent was stopped for a traffic violation. Under the dash of his car, the respondent had used magnets to attach a box. In the box were individually wrapped packages of cocaine. The total amount of cocaine was 4 grams or more, but less than 200 grams. The case was concluded on February 4th of 2014 when the respondent pled guilty to possession with intent to deliver cocaine, a first-degree felony. The court found that the evidence substantiated the respondent's guilt but deferred adjudicating him and instead placed him on community supervision for 5 years. He was born in 1976. He was approximately 21 when he committed his first crime and approximately 37 when he committed his most recent crime. The respondent submitted no letters of recommendation. He has committed 7 crimes in his life. The last one was the most serious. Further, it was committed while the respondent had a barber license, and it is directly related to the barber occupation. The department recommends that the commission adopt the PFD and deny the renewal and revoke the license. Take any questions?
Any questions, Mr. Rennick? I have some public comments form from Larry Thomas.
Yes, sir.
And from Terrence Edwards.
My name's Larry Thomas.
And you understand that, as I'll say it again, you can only bring in
I
what was
understand.
at the
I
hearing.
I understand.
And we need to confine our comments to just that.
Yes, sir.
Go right ahead. State your name for the record.
Larry Thomas. I'm an attorney in Harris and Fort Bend County for the last 37 years. And there is no argument about the record presented by the state concerning Terrence's background. What we would like for you to do is consider his socio-economic background and why these things happen. Since that time, the last hearing, Terrence has a barbershop of his own with 8 chairs available. 4 are filled right now. He pays a house note. He pays the rent on his establishment, and he supports his kids. So I'm not going to sit here and try to walk around what he has done in his past. I would like to say to the commissioners that if you revoke his license, you're going to put a family in the streets. And from him being a taxpayer now and a member of society who's contributing, you'll put him on the rolls of having to take care of him out of your tax monies. So in considering the ALR considerations in this matter, we would ask that you consider allowing him to continue working in some manner.
Mr. Edwards, did you have anything that you wanted to say?
Yes, sir. My name is Terrence Edwards. I can't deny what I had done. I say it was wrong, and I've been through a depressing state of mind after I lost a loved one, so it caused me to fall back on.
I'm sorry to interrupt. I just want to make the commission aware that the respondent did not testify at the hearing. There were no witnesses at the hearing.
Oh, okay.
On the defense side.
It's going to be difficult for you to, you didn't testify at the hearing at all that took place?
No, sir.
Okay. Were you at the hearing?
Yes, sir. I was
Okay.
present.
Let's keep, unless these comments were mentioned in the hearing, let's keep them out of here. Let's just simply state what was at the hearing itself. That's all we can consider.
Okay,
That's been said is what took place.
Okay.
And then why we're here today is for you to consider his revocation.
I'm just going to go ahead and mark through your public comment form, just so you know. Any questions for Mr. Thomas?
Was he represented by counsel at the hearing?
At the first hearing, he was, yes. I was there. Unfortunately, he didn't hire me until the day before. So coming from Harris County, there was no way for me to prepare. I guess I should have asked for a continuance, but we have no, we're not refuting his record. We're just asking that he continue to work on probation or some kind of way, because he's contributing now.
Any further questions? Well, and as you heard before, my issue is that we have so many cases. And, but the last one dating back in 2014, well, the offense was committed in 2013, I'm sorry, but it was, the case was in 2014. And they all seem to be drug-related. So, I have a problem with that. Any further questions? Thank you. Feel free to have a seat if you'd like.
Thank you.
Commissioners, motion or comments?
I have a comment, Mr. Chair.
Yes, sir.
In this particular case, I see that because it is drug-related and because the public contact is one-on-one, I really have a real concern with the issuance of any license to this applicant at this point. So I'll wait to hear from somebody else, otherwise I'll be ready to make a motion.
Further comments?
I think my concern is that we took a chance and issued a license back in 2009, and it was a risk that we were taking then, and you know, that's my biggest problem, is that we took a chance in 2009, and now do we take a chance again? I don't feel comfortable now.
No further comments, Commissioner Shaw, you have a motion?
Well said, Mr. Commission. The commission, if you're okay with this, I'm going to go ahead and make a motion to accept the PFD as recommended by the ALJ to deny Mr. Edwards' renewal application for Class A barber license and revoke his Class A barber license as well.
We have a motion on the floor.
Second.
About to say it dies. And a second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. So they'll be in touch with you.
Thank you for your time.
Thank you. Let's move on to item number 7. Jeremy Smith.
All right, Commissioners, Jerry Smith.
Yeah, feel free to leave. Yes, that's fine.
The department seeks to deny this respondent's application to renew his cosmetology operator license and revoke it. He was originally licensed in 2006. In March of 2014, the respondent was placed on deferred adjudication for 2 years for indecent exposure. The crime occurred on May 28th of 2013 when the respondent drove up to a woman who was walking in a Kroger parking lot. The respondent asked her where a Walmart was. When the woman looked at the respondent, she saw that he had his pants down and was touching himself. The respondent was approximately 31 years old when he committed the crime. The ALJ recommends that the application be denied and the license revoked because of the short time that has passed since the crime was committed and because the applicant failed to attend treatment as required by the terms and conditions of his community supervision. The department recommends that the commission adopt the PFD, deny the application, and revoke the license.
Any questions for Mr. Rennick? Is anyone here representing Jeremy Smith? Commissioners, comments or motion be in order?
Motion to adopt the PFD as written.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's take about a 10-minute break. I know that the last couple of cases that we have, there's some comments and stuff, so let's go and take a short break and then we'll come right back. Oh, we're still on time. Calling K, calling K. K. Oh, wow. It's on now. Yeah, I knew when I got this one, like, this is gonna be forever.
Mr. Chairman, we're ready. You bring that down?
We'll go ahead and bring the meeting back to order.
See, everyone should have thought the way I did. We'd been out of here.
We're gonna move on to item 8, yeah, HA. Mr. Barrow, feel free to have a seat. Mr. Rennick, proceed.
Commissioners, the department seeks to deny the respondent's renewal application for a journeyman electrician license and revoke that license. On November 14th of 2014, the respondent pled guilty to the offense of indecency with a child by exposure and was placed on deferred adjudication for 5 years. The crime occurred on June 22nd of 2012 when the respondent, for his sexual gratification, exposed his genitals to his 12-year-old stepdaughter. At the time of the offense, the respondent was approximately 41 years old. The ALJ recommends that the commission not revoke the license and that you renew it. At the administrative hearing, the respondent testified that he did not commit the crime and that he would pled guilty to avoid the risk of conviction and to stop family pain. It's at this point that the ALJ, well, at some point in his PFD, the ALJ made a statement that is of great concern to the department because it creates a standard that we believe we are not required to meet. The ALJ states in his PFD that a, quote, complete record, close quote, should be developed regarding the respondent's claim that he was innocent of the charge. The ALJ is simply wrong about this. First, not only did the respondent under oath plead guilty to all of the elements of the crime, but also the district judge found that the respondent was aware of the consequences of his plea and that the evidence presented to the court substantiated the respondent's guilt. Second, Chapter 53 does not state that an agency must relitigate the district judge's finding, and it shouldn't, because the district judge and the district attorney have much more knowledge of and access to the evidence that any state agency does. We are unable to get any district attorney's file. We could not and cannot in the future relitigate a criminal case to prove to an administrative law judge that a particular defendant who pled guilty and was placed on deferred adjudication is actually guilty of the crime. Chapter 53 only requires, in a deferred adjudication case, that an agency answer 2 questions. And if the answer is yes to either question, then a deferred adjudication can be considered a conviction for Chapter 53 purposes. I'll talk about those questions in a bit. The ALJ, in his misguided attempt to relitigate the criminal case, allowed into evidence numerous letters from friends and family and a pastor, etc., who had firsthand knowledge of the crime, who had no firsthand knowledge of the crime. Chapter 53 allows recommendation letters, to be sure, but detailed accounts of what the friends and family believe happened in a criminal case are far beyond recommendation letters. If the respondent believed testimony of all those people was so relevant and important to his case, he would have gone to trial in the first place. One letter heavily relied upon by the ALJ was from a woman who added the words, quote, qualified mental health professional, close quote, next to her signature on a 1-paragraph recommendation letter. Commissioners, her letter has no letterhead. She describes herself as someone who has known the respondent since 2010. She does not say she is a medical or psychological health provider to the respondent. Further, she provides no details of her qualifications to judge the respondent. It is clear she is speaking as an acquaintance rather than an expert, and her opinion is no different than any other friend or acquaintance of the family. Yet the ALJ cited this as one of 4 letters that was so important to him. The other was from the victim's older sister, who provided numerous details of her living with the respondent and not seeing the respondent attracted to her, therefore the respondent must not have been attracted to her sister. These are all statements that would be considered or that she could testify to at trial in a criminal case, but they're hearsay as far as an administrative law case. Yet the judge, the ALJ, let it in under the guise of a recommendation letter, when in fact it is basically testimony about what she thinks happened in the criminal case. The other letter that was another letter that was heavily relied upon by the ALJ is one from the respondent's community supervision officer. This letter contains a total of 4 sentences. The officer says that he supervises the respondent. The officer says the respondent is compliant with his probation conditions and is highly motivated to complete his treatment. She says the respondent is paying his fees. Finally, she says if TDLR will allow the respondent to maintain his license, it will ensure that the respondent successfully completes his probation and fulfills his financial obligations. Please note, Commissioners, that the respondent has not completed his community supervision and, more importantly, has not completed his treatment. As I mentioned earlier, the Commission under Chapter 53 should decide 2 preliminary issues in a case like this. 1, whether the respondent might pose a continued threat to public safety, or 2, whether the respondent's employment in the occupation at issue would create a situation where the respondent would have the opportunity to repeat the offense of indecency with a child. Regarding the first question, the respondent swore under oath that in 2012, for his sexual gratification, he exposed himself to his stepchild. You have sufficient evidence based on that to find that the respondent might pose a continued threat to public safety. And that's the standard, might pose. And we believe that under these circumstances, he certainly might. Regarding the second question, it is not unusual please remember that it's not unusual for children, including female children, to be present on electrician job sites in homes and businesses. Therefore, the opportunity to repeat the crime clearly exists. Further, crimes involving prohibited sexual conduct and crimes involving children as victims are guideline crimes for this occupation. If you answer either question yes, the crime becomes a conviction for Chapter 53 purposes, and you may deny the renewal and revoke the license because it was committed within 5 years of the renewal application, if you choose. That's Section 53.021A2. You may also deny or revoke the license because the crime is directly related to the occupation. Now, the factors that the department thinks are very relevant to the question of whether it's directly related are that the crime is a clear guideline crime. It occurred only 4 years ago. The respondent has been supervised for only 2 years. The crime was committed while the respondent held our license as a journeyman electrician. The victim was only 12 years old. The respondent was in a position of trust with this victim. The respondent was 41 years old at the time the crime was committed. And finally, the respondent has not completed his treatment that has been ordered as part of his community supervision. The department recommends that the commission reject this PFD, deny the renewal application, and revoke the license.
Any questions, Mr. Rennick? Joseph Barrow? You go by Joseph?
Go by Eddie.
Eddie?
Yes, sir.
Okay. We got Joseph Edgar Barrow and then Angela Dawn Barrow.
That's correct.
I think you've heard me before.
Yes, sir.
Prior to knowing that you can only speak.
Yes, sir.
And bring in what was heard at the hearing itself.
I understand.
So, I assume that you were at the hearing also?
Yes, sir.
Okay. All right, if you don't mind, state your name for the record.
My name is Joseph Edgar Barrow.
Go ahead.
I have a brief history. I served 6 years in the military, active duty, Navy, and 2 years after that, started working as an electrician after I got out. And in 2002, I joined the reserves, and I quit going, being a part of the reserves. I got discharged honorably, but this situation caused me to stop going. I've worked as an electrician for 14 years without incident. And I started with this company in 2010, and it's done, most of 90% of their business is schools, active and ground up. And I've worked on both situations, elementaries, junior highs, high schools, without incident. Concerning the matter here, my wife and I both feel that, and this was on the recording of the hearing, that her middle daughter had an incident with somebody who was living with her father, and she asked to come live with her, and her father finally agreed, and we paid for a plane ticket, and she came to live with us. He was coerced and having sex with him, and he was 20-something, and she was 16.
By a roommate.
By a roommate. And the age of consent in Georgia is 16, so he didn't have any trouble or charges brought against him. So she came to live with us, and then after seeing that and her desire to want to come live with her mother, because every time she'd come visit, she'd always state that she wanted to come live with her mother. She didn't like it in Georgia, and for various reasons. And we both feel that she wanted to ring the bell. She just didn't want to ring the bell that far. You know, she wanted the same attention or same kind of outcome or some kind of similar treatment. You know, when trauma victims usually go through trauma such as this, they recede, they withdraw, they suffer in school, but she didn't do any of those. She didn't suffer in school. She makes A's and B's. She's a part of 2 sports teams. She's always been overweight, so that was, you know, she didn't gain a whole bunch of weight after. So, you know, we're just trying to move forward. I'm not trying to relitigate the case as proposed by the prosecutor. I just don't know how else to state what happened and the reasons supported it in our decision. Because the way my attorney was explaining it to me, and in the way we felt, it was around Thanksgiving, and people, when they see these kinds of things, they go by how they feel more than the facts. And it was just me, and the only piece of evidence that I had that was going for me was a polygraph. And it wasn't just some polygraph. This guy wrote some of the statute for sexual offenders. For I have it with me if you'd like to see it, but it's in the and he felt it was. I tested so strongly that he even offered to test Abigail for free. You know, but that would never happen. But that was offered, and when my attorney was explaining about lesser includeds, and even if they found me not guilty of the 2 charges, that she could bring up the lesser includeds, and then I could be charged with that. And there was no probation for what I was being charged with. It was either I get not guilty or I'm going to jail. And I already got a son whose father committed suicide on Mother's Day in 2009. So that's, you know,
Take your time.
So we all do things that are hard. So we made a hard decision to move forward. For a family. And have some kind of life that was just, I couldn't see as going to jail. You know, she was like, you know, you wouldn't survive jail with a charge like this and all this stuff, and it was just, you know, it was just too much. We didn't know what to do. So I took the deferred adjudication so I can move forward. This is all I got. This is what I love to do, and I do it good. And I do a good job. There's no time to, I mean, I even get ridiculed at work because I don't go to places like Hooters and Twin Peaks. Even before this happened, and I could go, you know. And I don't look at the girls walking down the road like they do. And I've even sent guys home, like we work in schools, and they're looking at girls that are in the school, and I send them home, you know, because I'm a foreman.
Any of this is in the record.
This is what? That was in the record, because I said it to the Judge Broyles, and I made a point of saying that. And we didn't even go back and listen to the recording.
Okay, go right ahead.
Because I think it matters. I mean, that states to my character, and everything that he says is hearsay to the letters. I think that's how they feel about my character. You know, it may be a fact of the case that they feel I'm innocent, but it states to how they feel about my character. I believe, and they believe in me. And they would have no problem with me being around their children. And every one of them had contact information. If he worried about it, why didn't he contact them? Ask them questions. I mean, that's why I had everybody, I didn't know the guidelines of tell them how to write it. I didn't want any kind of, to tell them how to write it, because I didn't want it to be handled by me or guided. I wanted it to be their words. So I didn't know exactly what to tell them. I've never done this before. I don't have any kind of record. And the witnesses that for all the letters, that they only matter in a case like this if you get guilty. You get a sentence of guilty. It only matters to lessen your sentence. You can't bring them to call the character witness. It's only what she said, what the video interpreter said, and what I said. And that's pretty much it. And it's a 3-day trial. And then it goes to a jury, and then and your life's in their hands. I just couldn't take that risk. You know, that's the bottom line. My employer knows. My employer supported me throughout all this. I'm on jobs where I don't violate my probation. I'm running a job. I'm working by myself, and I make production. I do jobs. You know, they bid them. They bid work just to bid work to keep us busy, and I always beat labor on it because I got to keep busy and I'm diligent and I know how to make things work. I mean, I tell her, my wife all the time, I'm anointed to make things work, fix things, because things I don't know what I'm doing, you know, I just pray about it and things just work out. I mean, things didn't work out obviously in this case, and I've even had issues with God, you know, where I've had, you know, that I was, you know, angry. But we're just trying to move forward. And there was Mr. Rennick came up with, after the ALJ stood out the findings that I keep my license, Mr. Rennick came up with, I think, 4 objections. And when that, I don't know if Kathleen partially wrote it, or if she's on the letterhead, but Judge ALJ Broyles signed it. He says the staff incorrectly infers that there's been a final conviction. To the contrary, this criminal case is open and will be dismissed if I fulfill my agreements in the plea bargain. This case is not a final case. The decision was based on a contract or plea bargain between the defendant and the prosecutor, each way in many factors. And in 2.5 years, I'm eligible for early release from probation, and my attorney can vacate the registry. I only got 10 years registry. I didn't get a lifetime registry. So in 2.5 years, it's going to be free of this. 1.5 years. Actually, 1 year, because I'm 1.5 years into it. And then the deferred adjudication cases are some of the most difficult to arrive at, stated the ALJ. And the ALJ is unaware of ever recommending licensure for a person with deferred adjudication in the past. In fact, on reading the notice of hearing and preparing for hearing, he doubted, while obviously not deciding, that I would effectively rebut the staff's evidence in this case. But even while rare, this type of case is precisely when the evidence obtained through a contested case hearing must be weighed carefully to determine if an exception should be made as allowed by law. In this case, after long and careful deliberation, the ALJ recommended that Mr. Barrow be allowed to keep his license. He is not a threat to public safety, and his employment in this occupation will not create a situation for a repeat offense. A statement of purpose, the decision is not made rubric. I didn't know what that meant, so I had to look it up. And I still don't know what the rubric, how it applies. As suggested by staff, rather is a decision that is made based on the entire evidentiary record, including the credibility of the witnesses, and many factors indicated in the regulations, including the letters of recommendations. In this particular case, we also have a polygraph examination that Mr. Barrow is required as part of his community supervision to take. He says monthly, but they're yearly polygraph examinations that assures his compliance with the probationary terms. This is the case where hearing the evidence, a recording is available for the commission, if you so choose. And he said in the first part that the plea bargain is a contract between me and the prosecutor, and it is not a conviction, and there are many factors that go into it. And for the commission to consider that and then whether it might pose a threat to public safety and ultimately a licensure. And I just ask today that you uphold that, the PDF decision, or what's it called? The ALJ's decision.
Ms. Barrow, did you want to speak also?
Yes, please.
Okay, I'm going to need you to sign this before you leave also.
Yes, sir.
Go right ahead. If you don't mind, state your name for the record.
My name is Angela Barrow, and I'm proudly Joseph Barrow's wife of 5 years. We've been through a lot together. Some really great times to start with. As normal as I've ever experienced life with any person up until this happened. It was so normal. Actually, the only thing he's only had dysfunctional was me and my life. I stated when we came in that my marriage to my first husband was so dysfunctional, and my divorce was so bitter. We fought over our 3 children so bitterly. There were police called constantly. In fact, I threw a set of keys at him and he put me in jail. And because it was a domestic violence issue, he filed assault charges. So if that just gives you a little, insight, which everything was dropped after I went back to him and everything, but if it just gives you a little insight to how bitter things were after we actually divorced. We played tug of war and fought, and the kids saw everything. And I'm not going to lie to you. These kids were just mentally, in every way, destroyed. And I'm ashamed of myself. So, to try and keep this as short as possible, I want y'all to know that the oldest daughter, and this is on record, the oldest daughter at the age of 12, I did, and it is the Children and Protective Services of Georgia. She did molest the 2 younger daughters, and that is on record in Georgia. And we went through that.
Was that brought forth at the hearing? Okay.
It was. And then as well as there was an incident, as as he was speaking of, that my first husband had a roommate. He was 24 and had given she was actually 15 at the time, but at the time that actually it was found out she was 16. The age of consent in Georgia is 16, and she said it was consensual, and he had given her drinks, and they had sex, and my husband didn't, my ex-husband didn't want to have to go through it, so he just agreed to allow her to come live with me here in Texas, and swept it under the rug. And so the youngest daughter had seen and been through a tremendous amount of just terrible stuff. And so I guess what I'm trying here to say is that I do believe that my youngest daughter was traumatized. There is no doubt in my mind that she was, in fact, hurt. And I want y'all to know that I talked to all 3 of my daughters. We have maintained a relationship and are maintaining a relationship now. And we're working through everything with God's help. And my little boy, we're living in 2 separate households. I'm raising him. He lost his first father to suicide. God bless Eddie. He works hard. He helps sustain 2 households and allows me to homeschool my son with autism. And we've been through a lot, but God is good and he's been faithful and we're moving forward. And I'm not asking you to believe us or I'm just asking you to help us move forward in our lives. Give us a chance to prove that we can do this. Please.
Any questions for Mr. and Mrs. Barrow? Mr. Rennick.
I'd just like to say that with listening to Mr. and Mrs. Barrow is a perfect example of what the issue is in this case. They came into the hearing and the judge allowed them to testify as to all this evidence that they claim their daughter, basically they're telling you that their daughter had emotional problems and can't be believed when she accused Mr. Barrow. That's the upshot of everything they're saying. But I don't have the district attorney's file. I don't know what's in that file. I don't know why he was persuaded to plead to this crime. Because he might have been, for all we know, he might have pled to this crime because the evidence was so overwhelming. He didn't want to risk going to trial because he didn't want to serve 30, 40, 50 years in prison. We just don't know what the facts were at the time. And that's why we're at such a disadvantage and why the legislature didn't want to put us in this type of disadvantage, because we can't retry these cases. He pled guilty. The judge found that the evidence was substantiated his guilty plea. That's all we have. And that's all we can have in these deferred adjudication cases. And they can come in and swear under oath at an administrative hearing they didn't do it. But there's nothing we can do about it. We can't attack what they're saying because we don't have the evidence to do it.
May I add to that?
What is that?
If the evidence was so overwhelming, I had 2 second-degree felony charges, and they pled down to a 3rd-degree felony by exposure with 5 years probation and 10 years registry. Overwhelming evidence, they don't plead now. It's 10 years, probation and lifetime registry.
And may I ask how Mr. Barrow has such extensive knowledge of what this...
Because I'm in group with because I have going to sex offender therapy, and I'm in a group with 9 other men, and these issues are brought up. You know, the circumstances are brought up. So, but you know, you're not, you know, you learn how things are different, or how it was different in your case, or it was different for somebody else, and there's all different kinds of cases there. I'm the only one in that room who has a registry that can go away. Everybody in there has a lifetime registry. They have to every year they have to go and register as a sex offender.
Any further questions for Mr. Barrow, Mrs. Barrow, or Mr. Rennick? Thank you. Feel free to have a seat. Commissioners.
I'd like to make a motion that we accept the PFD as presented.
Second.
We have a motion, a second, to accept the PFD as presented. Any further discussion?
Can we have some discussion?
Yes, sir. Commissioner Shaw.
So for Mr. Rennick, I have a couple of questions. Am I correct in stating that the license was issued to Mr. Barrows, a journeyman electrician license, in 2005, and he held that until, as of recent?
He
10
still
years?
has the license.
He still has the license.
We're trying to deny his renewal and revoke the license.
Right. The second question is, I did not see this, and maybe you can help me. Were there any other criminal history before this one?
Nothing, I can't say there was, no.
And was the application completed
As far as the answer to the criminal history question, yes.
Thank you, sir.
Any further comments by the commissioners?
Can I comment to Mr. Shaw's?
No, we've already closed everything. We're just answering questions now. Any further questions? We have a motion on the floor. All in favor signify by saying aye.
Aye.
Those opposed? Okay, if you don't mind taking roll.
Luann Morgan,
Aye.
Catherine Rodwald,
Aye.
Ravi Shaw,
I'm struggling. I am not quite prepared to take a vote, but I have to, and I understand that, so I'll vote aye.
Deborah Yurko, Mike Harris Mendez.
No. Motion carries, and the PFD is accepted. So, by the way, thank you for your service.
Thank you, sir.
Let's move on to item number 9. Jose Duran.
The department seeks to deny the renewal of an apprentice electrician license and revoke that license. Respondent was originally received it in 2008. On September 16th of 2014, he was placed on deferred adjudication for 6 years for the offense of burglary of habitation. The crime occurred on May 19th, 2014, when the respondent and 3 friends were seen burglarizing a woman's home. The 4 were loading property from the home into a car. The car was in the victim's driveway at the time it was seen. The respondent did not know the victim. When the police arrived, some of the victim's jewelry was found in the respondent's pockets. He was approximately 22 years old when he committed the crime. Total value of the property recovered was almost $9,000. The ALJ recommends that the application be denied and the license revoked because of the short time that has passed since the crime was committed, because of the seriousness of the crime, because the crime is directly related to the occupation, and because of the lack of rehabilitation evidence provided by the respondent. The department recommends that the commission adopt the PFD, deny the application, and revoke the license.
Any questions for Mr. Rennick? Is anyone here representing Mr. Duran? Commissioners, a motion be in order?
To adopt the PFD as written and deny respondent's license and revoke it.
I'll second that.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 10, Lance Williams. Mr. Foster. Ms. Barrow, before you leave, make sure to sign that document. Kay's got it up there.
Yes. Good morning, Commissioners. I'm
Morning.
Ron Foster, Senior Prosecutor in the Enforcement Division. I will be presenting the matter of Lance Williams. Mr. Williams was assessed a $3,000 penalty in August 2014, and at this time he has not made any payments towards that penalty. Because Mr. Williams failed to comply with an order to pay the assessed penalty, the department opened this case to revoke his technician license. Respondent has been provided ample opportunity to arrange to pay the assessed penalty, however he has failed to do so. The judge proposes to suspend Mr. Williams's technician license until he decides to pay the proposed, the previously assessed penalty. The department recommends modifying the PFD conclusion of law number 8 to impose license revocation as provided by the department's enforcement plan.
Any questions for Mr. Foster? Is anyone here representing Mr. Williams? Commissioners, a motion would be in order? Or comments?
Move to adopt the order as presented. I guess it would be to suspend until the respondent makes arrangements for the payment of $3,000 in the appropriate case ACR 201-300-10154.
I'll go ahead and second that, sir.
We have a motion and a second. I can tell you that the issue that I have is that he has not made a payment and to date still hasn't.
He has not. He, during the SOA hearing, the judge continued the case, which I agreed to in order to provide the respondent an opportunity to come into a payment arrangement with the department. He failed to do so.
So I guess we haven't had any contact with him?
Not after the SOA hearing.
And yet, the motion is to suspend the license until he makes a payment.
Exactly. It's basically the status quo. There's nothing that would happen to his license.
Okay.
I just went with what they wanted.
Sorry?
I just went with what they recommended.
That the AOJ recommended? Yes.
Yeah, the department is recommending revocation based upon the enforcement plan.
My mistake. I didn't realize that. I'm sorry. I
Yeah,
missed that little technicality.
Sorry.
The AOJ.
Then I would move to revoke.
So you want to withdraw your motion?
Yes, can we renew this and have a do-over?
Okay.
Can I have a mulligan?
So we're withdrawing the motion, and you're
I'll
saying it's
withdraw.
okay. Commissioner Yurko, you want to try this again?
Hey, so I would like to move to.
Modify the PFD
Modify
and
the
revoke the
PFD.
license.
Here, I've got my wording somewhere. Modify the PFD as written and revoke the license?
Correct.
That would be based on conclusions of law number 8?
Yes, sir.
Okay. We have a motion on the floor.
I'll second.
And a second. So all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 11, Eric Shalev, is that right?
That's how I'm pronouncing it.
Okay, well, we'll
Keep
keep pronouncing it that way.
Shalef.
Shalev, okay.
Again, Ron Foster, Enforcement Division. Mr. Shalef is currently licensed as an auctioneer. The judge has proposed a penalty of $1,500. The department agrees with the proposed penalty and recommends the commission to accept the PFD. The judge found that respondent did not maintain his auctioneer business records as required. Although he did produce some of the records when the department requested, he did not have all of the required records. The department's ability to conduct a full and thorough investigation is hindered when a licensee fails to maintain required documentation. Respondent's failure to keep the records is a Class C violation. Enforcement plan calls for a penalty between $1,500 and $3,500 and up to 1 year probated suspension. The department recommends the commission adopt the PFD as presented with a $1,500 penalty
And not revoke the license.
and not revoke the license.
Okay. Any questions for Mr. Foster? Is anyone here for Mr. Shalev? That would be about right, wouldn't it? Okay.
Make a motion to
Yes.
adopt the PFD as presented.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to the motion for rehearing.
Good job, Ron.
Thank you, Ms. Foster. I believe we do have Sandra Marin from Pink's Beauty Salon. We do have our interpreter, in-house interpreter.
Good morning,
Ms.
Commissioners.
Lindquist, go right ahead.
I'm Della Lindquist, Deputy General Counsel. This is a default motion for rehearing based on a default order. Apparently, there had been a fine assessed against Ms. Mudding several years ago. She claimed she attempted to make the payment, although it apparently was a check that was insufficient, covered insufficient funds.
Della,
Yeah.
could you pause so that Irma can
So we can,
provide that information to her? So she
we got to interpret.
Right.
So she needs to
that's for the
interpret.
interpreting.
Yeah, she's
Oh.
going to interpret too, so she knows what's going on, so.
Okay. I had also originally spoke to Irma about the facts, so.
So,
okay.
have you relayed the information to her?
Yes.
Okay.
Sorry about that,
That-
Della.
that-
I wasn't aware.
Go ahead, Bella.
According to the respondent's motion, she did attempt to pay the previously assessed fine. However, it was an insufficient funds check. She has subsequent to all of that made good on the check and paid $1,300 to the department. Because there's no error on the part of the department in all of this, we recommend denying the motion for rehearing. But to be consistent with decisions you've made in the past, you could probate the revocation because she has paid the payment in full for 1 year.
She has paid the payment?
Yes.
Okay. Any questions for Ms. Lindquist? Ms. Marin, if you don't mind, state your name for the record, and we can only take into consideration this is a default case, is that correct?
Yes.
Any reason of the default case as to why this happened or why we didn't able to pay, so. if you don't mind.
Diga su nombre.
Buenas tardes, yo soy Sandra Marín. ¿Qué le quiere que le diga?
Go ahead.
Sandra Marín. Sí, lo que pasó, yo mandé el pago Y no se me comunicó, no supe nada de lo del cheque. Y yo estaba bien trabajando, y no estaba enterada hasta que saqué la licencia y apareció.
Go ahead.
I submitted the check, the $1,300 check, without being informed that it was bounced. She never realized it bounced. I kept on working until I was notified that it was still pending.
Mr. Chairman, since the staff has recommended that the denial be, the penalty be probated.
That's true.
That we can cut through a lot of that if.
Probably so.
Irma, would you explain that that
Let her know.
was settle the case?
Yeah, let her know that the recommendation is to go ahead to deny the motion for a hearing, but to probate the revocation for a year,
Which would allow her to work.
which will allow her to work.
Okay. La situación que estamos aquí, le van a permitir agarrar la licencia por un año, siendo que porque le estaban pidiendo que tenga una revocación condicional, y siguiendo las leyes y las reglas y pagando lo que les dice.
So I'm going to take a mulligan and we'll start over on that one. So is she interested in speaking at all? Because she's going to get basically what she wanted.
Está interesada en decir algo más porque le van a aceptar lo que usted estaba proponiendo. No, está bien.
Okay.
She's fine.
Then I'm going to mark through
Well,
this.
I will say she's not maybe getting exactly what she wants, but she will be allowed to
She'll
continue
be
to work.
allowed to keep
Okay.
working, which I think is what she wants.
Ajá.
Let her know that.
No está agarrando exactamente lo que pidió, pero le van a permitir trabajar por un año y seguir con
¿Y
todo
después
lo
del
demás.
año qué?
No, mientras que
Here we go.
después de un año se acaba esto y se cierra el caso.
Ah, ok.
Okay.
It's okay.
So she's okay. Basically,
Yeah,
what
she's okay.
happens is that she's paid the fine, got it all cleared up, and so her license will be probated for a year, but she can keep working after that, then we're back to square one.
Por un año va a tener la licencia convencional hasta que siga todo y luego ya todo lo demás sigue igual.
Okay.
Okay.
So, okay, we're good to go. So a motion would be in order.
So moved.
Amarita, a su dirección.
We have a motion to deny the motion for a hearing, but in the interest of precedent and consistency to probate the revocation for 1 year. Second? No? Motion dies for lack of a second.
Really?
So,
I've just been doing it the whole
okay.
time, so I was going to give someone else a chance. I'll second hers.
Okay, well, let's go back to it. We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Boy, talk about trying to kill this thing. Okay, we're good to go. Thank you. I think that concludes all the cases of motion rehearing. Let's move on to item J, which is the discussion and approval of criminal conviction guidelines.
Mr. Chairman, as they're coming
For
forward.
driver safety.
This is Brian Francis. Christina, as well as the Assistant General Counsels, are aware that we're coming under some time constraints. So they're going to give you a very quick overview of the process and then walk you right through the meat of the issue.
Yeah.
And you're going to find that the issues coming before you have been completely vetted by the advisory boards. But just wanted to give you that, if you hear them talking a little faster than normal, they're respecting.
And I know that we have some issues with possible quorum. So
Yes, sir.
we'll, let's go ahead and proceed forward. And if you have any questions, feel free to ask. But again, in light of the timeframe.
I do have a comment, though. I will have a bunch of questions, so if we have an issue with a quorum, then maybe we need to establish some timeframes when we have agendas like this. I'd hate for our staff to put in all this work and then just have to rush through, and for us to sit here and just approve something without, probably deliberating as much as we should. So I just want to caution the commission and the audience and the staff that's listening in here that there's no intentions in the commission's aspect to run through these things real quickly
Absolutely.
without having the proper knowledge. So
Absolutely.
at some point, Mr. Chair, if you feel that it's necessary that we are not, running against a time crunch, I want to at least allow our staff to present their.
I agree. I agree completely. I think the question is also, which I guess, Brad, you could probably tell us, these rules that are coming up that we're looking at adopting, if we don't get to them is there any time constraints to have them approved today? Or,
They're all pretty much on the same track. We're looking at an October 1 effective date, which is, way out there, but we were trying to give plenty of lead time.
but if
Those
this is pushed over to our next meeting date of April, we'll still be okay?
Yes, we will.
Does that sound,
I've gotten the green light from executive on that, so yes.
we
will
got
be
green light
fine.
from Wendy, so we're good.
Oh,
Ask away.
there's
Which
one
ones?
wrinkle, the dyslexia therapists and practitioners advisory board, we were going to adopt that provision sooner so that the chair could appoint the board members. So we might, take that one.
Which is E, item
or
L?
give priority to that. Yeah, my
Okay.
Staff reminded me of that. So that
So-
might be the only thing we'd really have to want to get done today.
Well, I think in light of that, and I appreciate the staff being flexible and being able to move through it, but I have to agree with Commissioner Shaw. I don't think we need to rush through it as much. What we'll do is, just so that the staff is aware, we'll move from item J to item L to take up the licensed dyslexia therapist immediately after this particular agenda item, so that we can't get that one done before we start losing quorum. But in the event that we begin to start losing quorum, and we haven't gone through the rules, we'll simply push those off to the next meeting and take them then. But I do want to make sure we get all that we need to right now, so.
Absolutely.
That's good to know. So, Christina, all that to say is your turn.
Good afternoon, Mr. Chairman, Commissioners. I'm Christina Kaiser, the Director of the Enforcement Division. I'm here to present Agenda Item J. Along with me is Chris Russey, who is the Research and Analytics Specialist for the Enforcement Division. He's going to assist by having materials up on the board, and he will probably help answer questions if you have any. At Agenda Item J, you have proposed criminal conviction guidelines for the Driver Education and Safety Program. TDLR assumed jurisdiction for this program after the last legislative session. The criminal conviction guidelines are used in cases where the agency is considering whether to deny or revoke someone's license because of their criminal history. Many of those cases were before you today. These draft guidelines were developed by the enforcement work group of the advisory board, and specifically that is the Driver Training and Traffic Safety Advisory Committee. The enforcement work group consisted of 5 members of that advisory committee: Ricardo Benavides, Carlos Reyna, Nina Jo Saint, Francis Gomez, and Patricia Lark. And they met with staff in 2 meetings in December and then again in February, and we had some really heavy conversations about what kinds of crimes should be a possible basis for denying someone a license in this industry. After the work group prepared a draft that all the work group members were agreeable with, the criminal conviction guidelines were presented to the full advisory committee on February 25th, 2016, and the advisory committee voted unanimously to approve, or to recommend that you approve the criminal conviction guidelines. Ultimately, today we will be asking you to vote to approve the criminal conviction guidelines so that they may be published to the world. By way of a little bit of background, I'd like to tell you a little bit about the part of the process that you don't see before a case comes before you as a criminal conviction case that you have to consider. When applicants for individual licenses apply for the original license or to renew the license, they are subject to a criminal background check. The criminal background check is requested by our licensing division, and the results from whether it's from DPS or a federal criminal background check are returned first to the licensing division. The licensing division makes the initial screening of criminal background results with reference to these criminal conviction guidelines. If the licensing division finds crimes that they believe may be a basis to deny someone or revoke someone's license, they will then refer that matter to the enforcement division. When a matter is received in enforcement, the prosecutor, whether it's Mr. Rennick or Mr. Sharp, then makes another preliminary screening of the criminal history based on the criminal conviction guidelines, and can and often does clear the person for licensing at that point. If they believe that a denial is possible or a revocation is possible, then they will seek investigation to develop the criminal background of the person, get court documents, get police documents, get probation information, and so forth, and then ultimately make the decision whether we're going to propose to deny or revoke someone's license. As you know, if we issue a letter proposing to deny or revoke someone's license, then the full due process is available to that applicant to request a hearing before SOA and then ultimately come before you for final decision. Chapter 53 of the Occupations Code is the general authority that we rely on most often in license denial cases that are based on criminal history. It gives us broader authority than the provisions that are included in some of the individual industry statutes. Chapter 53 calls for a case-by-case analysis, and that is definitely what we apply. The criminal conviction guidelines are central in that case-by-case analysis. Specifically, Section 53.021A of the Occupations Code is the provision that sets out the bases on which we may deny or revoke someone's license. It says the agency may suspend or revoke or deny a license to a person who has been convicted of one of four things. The first category, the first of those four, is the one that is the whole point of why we're here today. The first category is we may suspend, deny, or revoke for a person who has been convicted of a crime that directly relates to the duties and responsibilities of the licensed occupation. That directly relates language is the whole point. These conviction guidelines are our attempt to document the categories of crimes that we believe are directly related to this industry. So the guidelines, ultimately, if you approve them, would be published, and they would serve to put the industry as well as the public on notice of the crimes that we believe are related and that may serve as a basis for denying someone a license. There's also a provision in Chapter 53 that requires us to issue these guidelines, so that's a more pragmatic reason for bringing this before you today. In the interest of your time, I will not walk through the guidelines and talk exhaustively about each category. I can describe them to you generally. When you look at the guidelines, you'll see that crimes are set out in terms of categories, such as crimes against the person, such as homicide, kidnapping, and assault. We have learned through experience that it is not wise to attempt an exhaustive list of every possible crime because from one jurisdiction to another, from one county to another, from one court to another within the same county, crimes are described using very different words, and so to try to list them here would be an exercise in futility. So we have determined that categories describing the type of crime are more useful. So, and then under each category, such as the first one, crimes against the person, such as homicide, kidnapping, and assault, you'll see reasons listed, and these are the reasons by which we're attempting to document why we think these crimes are directly related to this occupation. Some of these you've had quite a bit of commerce in other industries, such as the crimes against the person, the crimes involving prohibited sexual conduct, crimes involving children as victims, and the crimes against property. So I will leave those, and I will be happy to answer any questions if you have those about those. I'd like to draw your attention in particular to the last two categories of crimes that are in these guidelines. These were the subject of quite a lot of discussion among the group, and these two categories are the result of compromise among differing opinions in the group. You'll notice that the next to the last category, crimes involving the possession with intent to deliver, possession with intent to distribute, delivery, distribution, or manufacture of drugs. This is something that you see in some of the other programs that we administer, but not all programs. The group agreed that it was wise to include this category here because of the unique nature of the instructors involved in driver education and driving safety, their unique access to people in a sort of a private or semi-private setting, the ability to engage in further similar conduct, drug delivery or distribution, and also they're in a position to pressure or influence the people who are their students, whether those are adults or children, to engage in such conduct, to deliver drugs or manufacturer or whatever. By contrast, the group agreed to leave out simple possession, such as possession of a small amount of marijuana for personal use. The group agreed that type of crime was too far removed from the responsibilities of this occupation to include it as a basis for denying someone's license. And the last category also I would like to highlight, crimes involving the operation of a motor vehicle, including driving while intoxicated, intoxication assault, intoxication manslaughter, reckless driving, and fleeing or evading a police officer. And of course that means fleeing or evading using a vehicle. Since the bulk of the licensees that will be affected or applicants that will be affected by these guidelines are instructors, the group felt that a person who has this kind of criminal history, a criminal conviction or criminal deferred adjudication of this nature would not be in the best position to serve as an instructor for students who are trying to learn proper driving techniques.
Can I ask you something?
Yes.
I noticed, okay, so who else would they be evading from but a police officer for the crime? And were you saying, I'm not sure why there was a distinction on the last one? Reckless driving and fleeing or evading a police officer?
I'm sorry if I was unclear. The distinction I was attempting to make was this would not be fleeing or evading a police officer on foot. It would only be doing so with a motor vehicle.
Okay, but why would that be less? Just because he's teaching driving? I mean, if he's evading
Are you talking about evading or fleeing on foot also?
We had one today. We had a case here that involved fleeing, or he was convicted of evading arrest, but we never made a distinction whether he did it on foot or in a car. I'm just curious.
If you feel that should be narrowed, that would create another category.
No, not narrowed, more expanded.
Just say fleeing or evading.
We created this category after lengthy discussion to include crimes that involve the operation of a motor vehicle because of the unique nature of what these folks are teaching. I think the group felt, the work group and then the full advisory board felt that the connection with the use of the motor vehicle was essential.
Yeah, I'm ready to make a motion, but I wanted to ask a quick question. How close does this policy match how the previous department had their policy?
The previous agency did not have guidelines of this nature. They had some provisions that were probably intended as criminal conviction guidelines that were in their rules, and they were much more expansive, and they would have resulted in many more denials and revocations of licenses.
Yeah, Commissioner Shaw, I think that the process that TDLR has is the exemplary process of publishing those guidelines and going through the vetting process with the advisory boards and the commission, so that we really have a model system here that other agencies have not really caught up with.
Yeah, I was having a hard time looking that up. I couldn't find it, so that's why I asked this question. So, yeah, I have to tell you, you've done an awesome job of laying this thing out very clearly so that it's very understandable, so thank you.
Thank you.
I'm ready to make a motion to adopt the proposed new guidelines as published.
We have a motion.
Second.
Second. I assume that was the end of your presentation?
Yes.
Did we just cut you off?
No, you did not.
So we have motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you, Commissioners.
Thank you very much.
Good job, Christine.
Let's move on to item L, which is the discussion possible action of the licensed dyslexia therapist and licensed dyslexia practitioner.
Mr. Chairman, we're going to have Wendy Pillow lay out the first part. She's going to provide an overview of the process that impacted all the programs, and then Laura will deal specifically with the dyslexia process. So Wendy's going to talk about the process. Laura will deal specifically with the rules.
Okay. She's making her way up.
Okay.
Go right ahead.
I'll go ahead and start. For the record, Wendy Pello, Assistant General Counsel. We're jumping ahead to agenda item L, the licensed dyslexia therapists and licensed dyslexia practitioners program rules. But before Laura gets into those details, as Brian said, I do give you an overview that will apply to all of the rule agenda items today, items K through Q, and that these are the rules that implement Senate Bill 202. As you know, the Texas Legislature enacted Senate Bill 202 last year, which transferred 13 occupational licensing programs in 2 phases from the Department of State Health Services to the Commission and the Department. And under Phase 1, 7 health-related programs are being transferred, and all 7 of those Phase 1 programs are on the agenda items today under K through Q. The other thing I want to point out is Senate Bill 202 also amended our enabling statute. Do you need me to stop?
No, go ahead.
Okay. Occupations Code Chapter 51 by adding a new section 51.2031, which is related to rules for the health-related programs. And this section applies to 6 of the 7 programs, Phase 1 programs being transferred. The only one it doesn't apply to is the dyslexia program that Laura will just talk about in a minute. And under this section, the Commission may not adopt a new rule relating to the scope of practice or a health-related standard of care unless the rule has been proposed by the advisor or established for that profession. And for these types of rules, the Commission shall either adopt the rule as proposed or return it back to the advisory board. The Commission still retains authority to do final adoption. And this is a new twist. We wanted to bring this to your attention because this is very different from other program rules in terms of making those changes. And it's those 2 narrow scopes of scope of practice and standard of care. Don't think that'll be an issue today, but do want to bring it up because it affects 6 of the 7 programs today.
Well, and that's what I was about to mention, and of course, coming to the advisory board meetings, I think that, we're all having to adapt and kind of change a little bit. And that's one thing that I think the commissioners need to understand is that if it has to do with those 2 items, we can't just make the changes here like we would on any other program, but we simply send it back to the advisory board, and this could be a tennis match for a while until we get this volleying back and forth, because if they send it back to us and we say, no, this is not right, send it back again, then we could just be volleying back and forth. So I say that to let you know that because of the standard of care and the scope of practice, this is kind of a totally different realm for us that we're going to have to be adjusting to also. While we have the ability to say yay or nay, as far as being presented to us, we don't have the ability to change it. So I reemphasize that also so that commissioners can kind of get their heads around that whole thing is that, and we may try, but I'm counting on general counsel to slap our hands and tell us, no, you can't do that. And steer us right back down the path that we need to be at, because this is going to be new to us also.
Right, and related to that, there will be future rulemaking related to putting in process and procedures for how that works in terms of the standard of care, scope of practice, and there's some other provisions about enforcement and complaints that's also in that new section as well. So there'll be a future rulemaking to address those type of issues.
And then with the programs that we have here and the programs that we know are coming, they'll all have this same.
Well, this provision, as it's currently written, only applies to 6 of the 7 Phase 1 transfer programs. So it's all of the rule programs that are on your agenda today except for the dyslexia program. So it's none of the Phase 2 programs that are coming. So they were very specific when they wrote that section about it was just those 6 programs.
Okay.
If I'm hearing correctly, one size does not fit the rest of them. Am I correct? I mean, this is not going to be the template for the rest that are coming in.
Right, they added it as a standalone section. They added it to Chapter 51, but it's a separate section about, there's the general section about rules, 51.203, and then this is 51.2031, and it's rules related to health-related programs, and it specifically identified the 6 programs that it would apply to.
Makes sense.
And
Thank you.
Commissioner Shaw, everything's the same except for just on a health-related standard of care for these 6 programs. Correct. It could go back if the commission decided to reject it. But in terms of the process and how it's going to move forward, we've standardized and done our approach of making it very uniform so we still get those economies of scale and the efficiency that we have in the other programs.
Got it. Thank you.
Welcome. And just a little bit on that in terms of how we got to the proposed rules you have today in terms of the scope of the changes we made. And this is kind of a general high-level overview. Each rule section, each rule chapter will have its own specifics, but We started with the DSHS rules and then formatted those into TDLR format. We changed references from DSHS or their board or committees to TDLR and the commission. We also did a lot of streamlining. We deleted provisions that are common and that are already found in our Chapter 51 statute or in the Chapter 60 procedural rules. We didn't need to repeat it across all the programs. They made it standardized and made it look like a lot more of our other programs in terms of looking to Chapter 51 or Chapter 60 rules. We also eliminated any statutory provisions that were no longer supported based on the changes of Senate Bill 202. And then generally speaking, we tried not to make any substantive changes in this rulemaking to try and ensure a smooth transition from DSHS to TDLR. I mean, the goal of this, and we kept emphasizing this to our advisory boards, is the whole point of this is to transfer it from from DSHS to TDLR without really disrupting their lives and doing too many changes on that. So when we reached any substantive issues or people had substantive issues or changes that they wanted to make, either through a result of public comments or the advisory board discussions, the advisory boards referred those to advisory board work groups for further study and issue and discussion. So that's kind of the background, and except for the dyslexia program that Laura will get into details, for the most part we were wanting to have all the rules be effective October 1st, 2016, which would correspond with the transfer date of the program. So that's just a little bit of general overview, but obviously each program will have its own specifics.
Now Laura's going to talk actually about the licensed dyslexia. Is that correct?
Yes. And I would note that in the existing sets of rules that are coming before you for adoption, that there are a lot of provisions in there that sort of look to us like standards of care and scope of practice already that haven't been pulled out and identified that way in a particular section, but I wouldn't be surprised if some of those kind of move into those sections, so you may see some of that sort of looks like those already. You have before you the dyslexia practitioners and therapists rules, and these are going to be at new Chapter 120 in 16 Texas Administrative Code, and this of course is one of the programs that transferred in the first phase from DSHS. This is the only program that's moving from DSHS that doesn't have an advisory committee yet, and so the adoption of the rules will empower TDLR to form that committee. The proposed rules were published in the Texas Register on December 25th. The public comment period closed on January 25th. We did have a public hearing during the comment period on January 12th. Given that there's no advisory committee, we wanted to get some additional input from the industry. The department received written comments from four parties at the 4 written comments and then 3 oral comments at the public hearing, including from ALTA, the Academic Language Therapy Association, and the department had considered all of the comments, and we're recommending to adopt the rules. Now, the adoption would be in 2 parts, basically. We're suggesting to adopt 120.1.10 and .65 to 69, which are the authority, the definition section, and the sections on the advisory committee or board, so that we can work on getting that board established, so that we do have a board in place that can then do the standard of care and scope of practice and help us start regulating this program. So those sections would be effective April 15th. That's our recommendation, and then of course the rest of them would be effective on October 1st, like the other programs. There, of course, is no board, so there are no work groups set up for this particular program yet. There are 2 changes in the adoption rules that are not in your packets. One is just a minor cross-reference, and the other is in 120.24. There were a few comments about this. In the statute, there's a list of 11 requirements for training programs, and we only repeated one of those requirements in the rules because it needed to be updated. And there was some concern that we were saying that that was the only one they had to comply with, and they were kind of concerned that the other 10 requirements weren't listed in the rules as well. So we simply added in 120.24 that the applicants have to meet the requirements in that section of the Occupations Code 403-106, and that is, those are applicable to them even though they're not in the rules. And so that was just the main change that you don't see in the adoption packet. Otherwise, the changes are all, well, even that one, they're all have been reviewed and the comments considered, and so we don't predict any problems there. If you want to look at anything in the rules, or if you have any questions on it, I'll be glad to go through that. Otherwise, our recommendation is the adoption in the two parts.
Any questions for Laura or Wendy?
No, Mr. Chairman, I'm ready to make a motion.
So, and just for the record, you're recommending that sections 120.1, 120.10, and 120.65 through 120.69 be adopted April 15th of
Yeah,
this year?
an effective date of
2016 effective
April
date?
15th, yes.
And then the rest of it would be effective date of October 1?
Right.
As you said, that's my motion.
Second?
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Okay, for just kind of so staff is aware, I apologize. We're about to lose quorum. And I know that you put a lot of work into these rules. So we're going to give you about a month to start preparing some more. And we'll push it off, the rest of the rules, to our April meeting. I will, real quickly, go to...
One more? Was it just those two?
No, we've got 1, 2...
No, I know we have more. I thought there was one more for.
That had to be done? No, I think that's the only one that required a
We did the
date.
criminal convictions and the
this one
dyslexia
here.
were the two that.
Let's move on to item U, which is discussion of our meeting dates, just so the commissioners know. At this point in time, we have a meeting scheduled for April the 13th and then May the 18th. We have a tentative date set for June 29th. And I say tentative because of the fact that we have not received information yet on the strat plan. Once that information comes out, it may be necessary to move our meeting date up to June 15th, because we may have to try to approve our strat plan before then.
Do that May 18th.
I can't, I'll be out of the country.
May 18th?
Yeah, I'll be out of the country too.
Okay.
And April 13th, I'll be out of the state on business, so.
Okay. So, be advised that our June date may change. We'll take a look at these other dates.
Can
Right.
we split the difference between the May and June? When it's going into summer? Would it be possible?
Not meet May?
Well, no, meet closer to the end of,
We've
end
got
of May and
some-
early June, so.
We've got some date constraints on the April meeting, April 13th.
Right.
So, we're not gonna be able to change that one.
But I'm saying it's May 18th, if we're going to lose 2 of the 5 of us, and then you've got a June,
Till the 7th.
2 of the 7 of us, I meant, I'm sorry. And then you've got the June 18th, I just wondered.
Yeah, and that,
Right.
what we'll do is we'll take a look, in the event that we have to move our June date up, yes, we'll probably just do away with the May 18 meeting and combine it all together, because there's no sense in meeting, another 3 weeks after that. So, but tentatively right now, April 13th, May 18th, June 29th, that one is subject to change, and if we move it up, then be advised that we won't have that May meeting. That's correct, okay. Right now, there's been some scheduled dates that they would like to be able to give us, July the 20th or July 27th. Does anybody have a conflict on any one of those dates?
I do on the 20th, the 27th would be better for me.
So we may just look at the 27th. Also, August 24th or August 31st.
It's so far out there.
Yeah, we're going way out there this
Do
time.
the 24th, so we don't start hitting Labor Day weekend.
Yes, sir.
Mr. Chairman, with all due respect, we go through this exercise almost at every commission meeting, and we lay out a plan so far out, but yet, today we've let our staff down, in my opinion, for not having to complete the agenda. If I may recommend that, let's not go that far out. With respect to all the commissioners' schedules and calendars and upcoming issues that come up, today is spring break and I'm here. So my recommendation is let's not go too far out into August and September. Let's stay close to heart. Let's go with what the dates we have 3 months out. And let's plan accordingly, that when we have such a schedule, that we at least notify the commission that, hey, this may be a long meeting, and plan accordingly. After all, we are at the mercy of the citizens of Texas, so I just think that.
If the next meeting's that long, we might go a half day the day before and then proceed into the next day, or something like that, if we've got that much to cover. We can
Well,
do
and
that.
that's something
Or just
that.
know
that-
not to book early flights.
Well, that's something that we're going to have to discuss, because I agree with Commissioner Shaw, and I know that at the last meeting, I requested the commissioners book later
Yeah.
flights
We did.
because I knew that we had all the rules. So I just ask you to take that into advisement and book a 5 o'clock flight, knowing that we're going to be here most of the day. That's what I would say about that. So
That was a problem.
we will, let's go ahead and leave it. We'll stop at well, let's just do the July date, July 27th at this point in time. And let's hold off there, and let's go, and let's not do any other meetings at that point in time. I agree. I can tell you, and I'll tell you again, in our April 13th meeting, I would advise you to book a very late flight, because we still have these rules coming back and we'll have cases coming in. We've only taken into account one rule in the conviction guidelines, and we still have, I believe, probably 5 other rules to consider.
6.
6 other rules to consider. So, and I can tell you that the advisory boards have put a lot of work into it. They've broken up into different subcommittees to work on this. And while it is a new program that's coming over to us, I can tell you they spend a lot of time on it. So I think we at least should provide the same due diligence on our own. So,
Mr. Chairman, we'll also have received the instructions for strategic planning, so we'll have an overview of the strategic planning process and even
we'll
results
know.
from some of our external focus group meetings.
okay.
Right, and those instructions will guide us when we have to have a meeting in order to approve the plan.
Right.
So that.
Which is the June date that's kind of
Yes,
up
sir.
in the air right now.
Okay,
So,
what I'm trying to figure out though is, because I have it easy, I'm here in town, so I can, but what I'm trying to understand is because over the course of these years, we used to, make it till 2 o'clock or 3 o'clock. And so I'm trying to figure out, do we need to start, like, if you're coming in the day before, at least do the afternoon half a day, and then get everybody in the morning, so we still get a full day in?
well, and I'm not opposed to that either. I think the issue that we had when we did that the last time was now we're taking 2 days out of work.
Right.
And so that was the issue, so we began to start confining it back to just 1 day. So, it's 6 of one, half dozen of another.
'Cause I just remember
Yeah.
originally we used to do this.
We did.
When I ran
4 or 5
into
o'clock.
today, like for today, and I guess I made my reservations too late, but even then, the 2 flights after the 3 o'clock flight were all booked. So I didn't have a later flight
And
after
we
3 o'clock.
And
so-
we have, like I said, in the past, we have done 2-day meetings. But the comments from the commissioners were that now we're having to take away 2 days of work.
Right.
And so that's the reason we went back to just a single day.
Yeah.
So I am not opposed to doing an afternoon and a morning meeting. I'm not opposed to that. It's just the wish of the commission. That's the reason we're looking at only single dates, because of the comments that were made. So,
Like I said, it's easy for me, so.
yes, sir.
Mr. Chairman, I started this issue, so I'll probably hope to end with it. One thing that you have to take into consideration when you do a 2-day meeting, half day, in the morning or in the afternoon, you're gonna have people coming in late, and I'd hate for us to do that as a commission, for people to straggle in. If it's a 1 o'clock meeting and if flights get delayed, you have commissioners coming in late. So I prefer to keep it at 8 o'clock or 9 o'clock like we have. Plan on a full scheduled day to be here, and should we end early, great. Let's chit-chat or hang out at the airport or wherever else. But I really feel that if we're expanding our time out here, if our staff is spending the time that they're spending, and if our board's an advisory board is spending the time that they are, I think we have to definitely give courtesy to them as well and to ourselves to fully vet what is being proposed to us rather than rushing through the agenda just because we are not meeting a quorum. Thank you, sir.
We've got,
And Kay, maybe you could help us, because since I missed the last month's meeting, I had no idea that it wasn't my typical 3 o'clock flight. When I made my reservations, I didn't know.
yeah, we'll make sure we just communicate back and forth, not a problem. Let's move on to item T, public comment. I had a Pat Johnson sign up, but I don't see him in here. So, you know you're not sneaking up here, right? So at this point in time, I'll go ahead and open up for public comment. Mr. Johnson, I do not see him present. There being no one coming forward.
Catherine? It's just one?
You know, we're about to lose quorum. I don't know if you guys want to do your reports. If you want to hold off, I mean, it's just going to be probably
We'll stack it up for the next meeting, just kind of let it aggregate.
So we know we're about to lose quorum, so why don't we go ahead and go back to the executive director's report, and you can go from there. Go back to R.
Mr. Chairman, members, a couple of quick points. We are rolling out the work from home policy. We had a meeting with the directors yesterday. We've done a video to notify all of our employees about that so that we can expand that process. We've been doing that on a pilot basis. When we did our challenge survey, that there was a significant interest of the employees into work from home flexibility, so that we're have the formal policy that we're getting ready to roll out for everybody.
Maybe that's what we need to do for our meetings.
Yeah.
Meet from home.
The agency is going to sponsor 2 Toastmaster groups. Next week, they will have the initial meetings at both the EOT and this North Campus. This is a really good opportunity for employees to develop the public speaking capability. That again was something that was in that challenge survey, that they'd like some more training in public speaking. So I think that we'll be able to be responsive to the employees' wishes there. It's a good opportunity to get a lot of the employees speaking. One of the things that Brian and I have done is have the division directors making presentations to you on a regular basis to give them the public speaking opportunities. The more we get in front of the microphone, the better we become, more comfortable we become giving those presentations. And I think that the agency is really going to benefit from that. On March 17th, I'll be testifying before the Defense and Veterans Affairs Committee on the issues that we've had before us for helping licensed veterans, and we've been, I guess, the lead agency in doing a lot of that. When the electricians program came to us in 2004, the statute gave us the flexibility to look at ways to verify experience of the applicants for their license. At that time, we developed a way to look at the MOS, Military Occupation Specialty, to determine whether people had the training and experience working with the electrical trades, and that was a very, very good process. That then morphed into recognizing military experience for the air conditioning license, and then finally there's been bills to recognize military experience for licensing for all licensing agencies. So it's our lead on that was very helpful. Randy Nesbitt developed the primer of the lessons learned that we went through with the MOS project. We worked with the Department of Defense on that. So we've got a very good foundation in reaching out to veterans and providing a fast path to employment once they come back from deployment. So we're happy that we're a lead on that. The ELITE program is for training for IT personnel. James Corral is participating in that this year. I'll also be speaking later in April, I think, at the ELITE program. I've already had one speaking assignment with that program. And it's something that I enjoy those speaking assignments with both Elite and with the Governor's Executive Development Program. And because of our working with them and providing speakers, we're able to get more of our people signed up for the courses, and that's been a real benefit for the agency. Simon Skegg has completed that. Tao has completed that. Glenn Bridge had also completed the Elite program training. So it's good to be able to get our people into that for the additional training for other activities in state government, other leadership positions. And we're getting ready to roll out the strategic planning focus groups. We'll start that on the 30th of March. And then we've got confirmed dates. That in March we have also McAllen. We will be having focus groups there. On April 11th, we've got focus groups in Amarillo, Texas, and April 12th in East Texas and Tyler. We're working on obtaining facilities for Corpus Christi, Houston, Dallas, El Paso, and Lubbock as additional sites for focus groups. We're just trying to obtain the space so that we'll have that available to invite the people in to talk to us about what we've done well, what we need to do better, what changes that they would see that we should make if they were the decision maker about deciding which change to be. As Brian says, if you're a king or queen for a day. And then finally, what issues are on the horizon that we need to know about so that we can stay ahead of things. We see a lot of the disruptive technologies now. Uber and Lyft are disruptive innovations for taxi cab companies. Those types of things, if we can see that coming down the pike, we can make adjustments ahead of time so that we're not trying to catch up after the fact. And I think that the strategic planning process that we have, that's as robust as it is, gives us the opportunity to solicit that information from the people that are in the industries and have an idea of what might be happening next so that we can be responsive as a licensing agency. That's the executive director's report. Brian, do you have any other?
I was just going to just add that Kay will be sending out invitations to the commissioners, letting you know the locations and which events. So if there's one in your area that you want to attend, you'll be able to put them in the list. And Mr. Kelly will be reaching out to other key stakeholders to make sure that they're aware of it as well. And of course, we'll send out an invitation to the listserv to our 650,000 licensees that are subscribed, including the listserv email includes the new health programs as well.
I have to make a comment. I had the opportunity to attend one of the sessions. It wasn't quite the same thing that you guys are doing now, but with Commissioner Moses in Dallas, and I have to tell you, having the boots on the ground and getting the information from the boots on the ground really helps TDLR. And I mean, this is unlike any other governmental agency that goes out and seeks that kind of input. I think that's admirable, what you guys are doing.
Thank you.
Because it's not always easy to hear it either. Because sometimes they may be telling you things that it's kind of tough to swallow, but it's a necessary process.
Got to hear it.
Yeah. Who do we have?
I have Ray standing by for a cameo from the education.
Ray, I'll give you 2 minutes.
Good afternoon, Mr. Chairman, Commissioners. My name is Ray Pizarro, Director for the Education Examination Division. Our division has been extremely busy. As you all know, with all of the new programs and all of the existing programs that we have, we need to keep up. Some of the services and some of the things we've been doing, first and foremost, is we continue to meet with the first one was the electrician program to go over the exam development, look over the items. As you know, the electrician exams has always been a talk of this agency, and specifically the journeyman electrician exam with the low pass rate. So we continue to look at those items and continue to work with the subject matter experts. In March this month, later on the week of the 21st to the 23rd, we're going to meet with the barber and cosmetology exam committee members to go over those exam items. We've had numerous inquiries from the schools requesting help with compliance via the site visit program that we have to ensure that they're interpreting the laws and rules correctly. Due to high demand, we are making some internal changes so that we can serve our educational providers more efficiently. We have staff from Austin that is going to begin to reach out to schools and assist them accordingly to relieve some of the workload from our inspection team. What we're doing is, just to give you a skinny on the site visit, we're going out to those education providers, those schools who don't understand, for example, what do I need to submit to get my curriculum approved? What's the difference between clock hours and credit hours? Why do I need to do this? Why do I need to do that? So we're going out there educating them and giving them a helping hand so that they understand what are the things that this agency is looking for, and try to help those schools so that they stay in compliance and stay out of enforcement, that kind of thing. We are working with the subcommittees to finalize changes that we need to make for inspections, specifically the driver training and driver education. We want to make sure that that we are maintaining some efficiencies while being consistent across the programs with respect to initial inspection and periodic. So we're kind of taking some of the ideas and some of the things we do currently with Barbara Cause and sort of mirroring that to the driver training program. So what we're doing is we're presenting those ideas and showing those rules that are already in effect for those two programs, Barbara and Cause, and giving them the daylight to the subcommittees and say, hey, these are the things we do in this industry, and your industry is very similar. What do you guys think? And we're having that dialogue through the work group. So that's it's very positive so far. One of the things we've done, something that's very outstanding, is we have the CE invoice project. We've had a lot of outstanding fees from the record fees that Barbara Cause and Tow they need to pay that $5 record fee for providing CE. They're collecting it for each student. We've had outstanding payments. No one was paying those fees. Since the inception of QuickBooks system, we have collected over $200,000, and since we've put in the QuickBooks, of the $500,000 invoices that we've sent out from the new portion of that, we've collected over $300,000, and we've worked very closely at a communication between our division and enforcement, and have been so great that we're able to make sure that we are holding these providers to what they need to do with letters of compliance, letters by enforcement. Some of them have been referred to enforcement. In fact, one even was their license was revoked for non-payment. So we are doing what we need to do to try to make sure that they stay right with the agency, stay square with us. A few other things real quick. With respects to all of the rules for driver training, we are working with the subcommittees to try to identify where we could expand, or where we could modify, if you will, or not have such large language in the rules, if you will. A lot of unnecessary rules, as you guys would. You guys know we like to try to keep those thin as possible and not try to repeat things that are already in statute by rule. So we're working with the subcommittees and kind of showing them showing our plain talk guidelines. This is what we need to do. Instead of saying this, let's say this, those kinds of things. So we're working with them. We still have a couple of more meetings that we're going to need to really dig down and roll up our sleeves with them and try to identify what things we need to change, what things we should not change. And of course, we're putting the ball on their court. This is not a TDLR writing rule session. This is for the industry to tell us, what are we doing? What do we need to do? What's needed? And so we're holding them to the fire and going to these advisory board meetings and the subcommittees. I think they're starting to open their eyes and say, oh, this is our opportunity. Let's get this done. So it's working really good. And since the inception of the driver training program, our division has issued 33 new school licenses and have renewed over 534 licenses. So that we're starting to get the momentum going and trying to, the chips are settling, the dust is settling, And I think it's going to be good in the next couple of years. I think we're going to see some, in my opinion, some major improvements and efficiencies in the program. And that's all I have.
And I can vouch that not only, I mean, Ray, of course, is having to work a lot with the licensing, but I mean, we've got, Christina's group with the enforcement side, of course, GC with the rules, and the programs coming over has just caused a lot of work to have to be done, but it's good work. It's a testament to the leadership of this agency and what we're doing, so hats off to everyone. So, thank you, Ray.
Thank you, guys.
Appreciate it.
That's all we had lined up for you today.
That, pretty much, I think we got all the cases, well, I guess it doesn't really matter, we don't have a quorum, so whether we got the cases done or not, Jim, if there's being nothing else, let's go ahead and just adjourn this meeting.